Therefore, this item now 29, my lord. It may be adjourned for 4 weeks, my lord. We are filing an application for amendment, my lord.
On the request of Mr. G. N. Sahalal and his senior counsel, preparing for a petitioner, the matter stands adjourned for 4 weeks. It is submitted that something has been taken from the land council for the respondents to make the
Interim order may continue, my lord.
29 interim order.
Interim order.
The interim order fast track shall continue till the next.
May I please, Lordship? I beg to mention for listing of a ex gratia matter. Any date, Lordship?
March.
Oblige.
May I please listen, my lord, I beg to mention item number 1, my lord. Due to, my lord, some documents were left out, my lord, I may be permitted to withdraw with a liberty to file a fresh.
Okay. Notice was issued actually.
My lord, notice was issued. I asked my junior for
Why it has
make a,
come for motion column?
no, my lord, I asked my junior to make a mention for either admission or for withdrawal, my lord. By mistakenly, it was listed for motion.
Yes, Mr. Talda.
I may be permitted to withdraw only, my.
My lord,
With a
the
liberty to
only
file.
difficulty is that in this case, your lordship has rejected the interim order. So
Hmm.
what will the effect, my lord, of this order in the subsequent case?
No, my lord, I'll
That is
annex
the issue,
this
my lord.
order also.
Let
my-
this matter remain. He may file a fresh, my lord. Because your lordship has already rejected.
No,
Now
my
the
lord.
cause of
I
action
pray-
cannot be
no, my
different.
lord.
Cause of action cannot be different, my lord.
No, my lord, cause of action is different on the, because, my lord, some document was left out. If your lordship permit me, my lord, I can show
In
document.
that case, my lord, lordship will record my objection, my lord.
And his objection may be recorded, my
What
lord.
will be the legal effect?
Yes, that is,
Mhm.
my lord, that has to be, my lord, adjudicated.
That will, I'll annex, my lord.
Bring it by additional
Yes,
affidavit then.
correct, my lord. Correct.
Otherwise, whether res judicata will apply or not.
Yes. This has to be
It's
adjudicated.
all right, my lord. Then all right. Then, my lord, lordship fix the matter, my lord, along with another connected writ petition, my lord.
I don't know. They tell me what will be the legal effect. I am not aware of such a situation.
Lordship has issued only notice, man.
No, hard
And lordship passed an order.
also on the interim prayer.
Yes, my
ma'am,
lord.
that is the interim prayer.
So may I pray, my lord, like this?
What will be the legal effect?
My
Tell
lord,
me as a
lordship
counsel.
fix the matter, my lord, any day next week. In the meantime, I'll,
Okay.
for admission column, my lord.
My lord, copies of the writ petition was not served on us. We are caveator
Which one?
in this case, my lord.
Okay, sir.
And neither
Yes,
on
yes,
me,
yes.
my lord. I have not received the extra copies
Okay.
of instruction, my lord. I cannot.
Okay, then let the matter reach.
Yes.
May it please your lordship.
It is difficult to pass long order. in motion.
Lordship.
My lord, with due apology and the consent of the other side, I beg to mention item number 6 of the daily list, my lord. We are yet to obtain instruction in this matter, my lord. May I pray for 3 weeks? time?
Petitioner,
I'm for the petition. I'm for the petition.
what instruction you have?
My lord, regarding this matter, my lord, they are challenging a so-called notice, my lord.
Let the matter reach.
May I please, your lord. With the consent of the other side, lordship, I beg to mention item number 33. I need to file affidavit in reply,
33.
lordship, affidavit in reply. And but the person who is representing the modern global economy, he's in bereavement, lordship. Therefore, 2 weeks time is required, lordship.
Okay.
And any day may be fixed, lordship, after 2 weeks.
Okay, Mr. R. Learned Counsel for the petitioner has prayed for listing of the case after 2 weeks in order to file affidavit in reply.
Lordship.
Okay, you have informed the other side.
Yes, yes.
Okay, Mr. It has been submitted that consent has been taken. It is submitted that consent has been taken from the learned counsel for the respondents to make the prayer.
All right.
May I please, your lordship, I would like to mention for listing of one motion matter on Friday, my lord.
Subject matter?
Subject matter, my mutation was cancelled. I filed revenue appeal. In the meantime, NOC for
What cancel?
my mutation was cancelled. I filed revenue appeal. In the meantime, NOC was issued for sale of the land, my lord.
May I please your lordship. My lord, I am for item number 37, my lord. This matter may be adjourned for the day, my lord. Then it may be listed after 2.
You are Mr.
Yes, sir, Borbogin.
Okay, on the prayer of Mr. S.R. Borvi and learned counsel for the petitioner. The case is passed for the day. It is submitted that consent has been taken from the learned counsel for the respondents. You have informed
Yes, my lord.
to make the prayer.
May I please your lordship, this is a mention memo for listing of a writ petition for a withdrawal. Lordship, kindly this matter may be listed as a tomorrow
Withdrawal.
withdrawal. Thank. Obligation.
Lordship, I beg to mention a matter for listing on Friday, your lordship.
Motion,
Yes, lordship.
motion,
Yes, your lordship.
subject matter.
Lordship, it is that same matter where I had impleted these, your lordship had allowed the implement of the state of Assam,
Okay.
your lordship. On Friday, my lord. Most obliged.
Lordship, I beg to mention item number 12. Matter may be adjourned for the day.
Matter,
May be adjourned for the day, Lordship.
okay, under request of Mr.
Ace Islam.
H. Islam. Learned Counsel appearing for Mr. B. Sinha. Learned Counsel for the petitioner, the case is passed for the day. Have you informed Deputy Solicitor General of India?
Yes.
Have you informed?
Yes.
Yes, MS Borua?
Yes.
Okay, MS Borua. Learned Central Government Council who is in attendance, has no objection to the same.
May I please, your lordship, I beg to mention for listing of WPC 6126 on Friday or Monday. Listing of WPC.
Motion matter,
Yes, motion.
motion.
Yes, I think, yes, yes.
Motion matter or admission matter?
It was last listed on
Mention
16th.
tomorrow
and-
after getting information, proper information. Yes, madam.
May I please your lordship, lordship, I beg to mention item number 43, lordship. Kindly adjourn the matter for today, lordship. Engaged counsel is out of station.
Okay. On the prayer of MS
And Kolita.
and political learning counsel for the petition, the case is possible for today. It is submitted as confidentiality.
May I please, your lordship, I'm sorry to trouble your lordship. Lordship, in item number 33, interim order was there, lordship.
Interim order is there.
Lordship,
Interim order passed the case.
lordship, deeply, I'm sorry, lordship.
For motion item number 1,
Hey, Harry.
May I please, Lordship? My lord,
1 minute. Yes.
my lord will see your lordship's order, my lord. And the
Hmm.
page 4 is the operative part, my lord.
So what do you propose? You will submit additional affidavit?
My lord, lordship will see, my lord. There is some order has been passed by the department that has been left off. That apart, my lord, that apart, the lordship kindly turn to prayer portion of the writ petition, my lord.
This is the application.
That has been left out. And lordship, the very nexus is the president, my lord, for which, my lord, all the trouble has started.
If
in
you
the-
want to bring it, bring it.
Yes, yes, my lord. Apart from
Because
this,
that is an old document.
yes, my lord. Because,
But
my lord,
you moved the petition on 8 December.
my lord,
Whatever is the bearing,
my lord,
will
another
be
thing,
considered.
my lord, lordship will see at page 16, my lord. Page 16, my lord,
Yes.
Roman 2, my lord. For setting aside and cause the impute AGM, my lord, 28/3/23. That document is not with us. So I asked my client to bring that, my lord. Anyway, no problem, my lord. Lordship will fix the matter, my lord, any day next week.
Otherwise, we have only considered the interim prayer.
Interim prayer, lordship has already said,
Otherwise, for other matters, we have issued notice.
my lord. Lordship will
Interim
fix,
prayer is, it may be modified
my
at
lord.
the
my lord.
time of final hearing.
Yes,
Or
yes.
otherwise, if you are aggrieved, There is remedy available to you.
My lord, remedy, my lord, what I thought, my lord, because that time earlier council was there, my lord, I was newly keen, my lord.
Okay,
Only-
when you want?
I want, my lord, any day next week, my lord, along with, my lord,
Any
WPC,
day next week is difficult, or some on fixed date.
possible fixed date, my lord, along with, my lord, WPC 2413/23. And so far caveat is concerned, my lord, until and unless we serve the copy, the caveat, the case does not register, my lord. And my friend, learned friend has said, my lord, we did not get the copy. Anyway, I'll supply, my lord.
8/12, my lord. My submission
In
was
both the
considered, an
situation-
order was passed.
Hmm?
While passing the last order, my lordship considered my appearance. my lord.
Heard Mr. J. Borhuya, learned counsel for the petitioner. Mr. S.K. Taludar, learned standing counsel, Cooperation Department for the response number 1 to 6. And Mr. J.M.A. Chaudhary, learned counsel for the caveator, who is implicated as party response number 7 in the petition. Full stop. Mr. Borhuya, learned counsel for the petitioner, has submitted that certain more documents, which will have a bearing in the writ petition, comma, are required to be brought on record by way of an additional affidavit. He has just paid for 10 days time to
7
file
days, ma'am.
such affidavit. Full stop. On the other hand, Mr. Taludar, learned counsel for standing counsel Corporation Department, and Mr. Chaudhary, learned counsel for the caveator response number 7, have submitted that extra copies of the writ petition in deference to the order dated 8/12/2023 have not been supplied to them. Full stop. Mr. Borhuya, learned counsel for the petitioner, shall supply extra copies of the writ petition in terms of the order dated 8/12/2023 within 2 working days.
During course of the day.
You are response number 2. Okay. 4. Then you are
I am, my lord.
okay,
1,
Taludar, you have 1, 2,
2,
3,
3, my lord.
5, and 6.
5 and 6.
Deputy Commissioner,
Ah,
District
yes,
Commissioner.
Yes, Borua, learned junior government advocate, some for 4.
My name may be shown in the book. It is not.
Okay, the name of Mr. J.M.A. Chaudhary, learned counsel for the response number 7, be reflected in the respondent side in the cause list. Today, 11, 3. please.
Along with, my lord, WPC
Leave
2413
the
of
case.
20.
No, my lord, this is a bench tree matter. Last week.
No,
this
my lord,
has come.
for reference, my lord,
This is a
it will
bench
come.
matter.
No, I cannot.
And the
Bench
honorable
matter, I
court has
cannot.
passed certain orders, my lord.
You get an administrative order from the Honorable Chief Justice. Otherwise,
And
bench
why,
matter,
my
if it
lord,
is
I want,
petition
already
my lord,
filed as bench
my lord,
matter.
that is the matter, my lord.
No.
Why, my lord,
No,
particular
Mr.
case,
Borhuya,
all the departmental are after
No, Mr.
this,
Borhuya, if it is already styled as bench matter,
Yes.
my lord, I
already styled as
I
bench
do not know
matter, I
what is
cannot.
the bench three matter, my lord. Why, my lord, my queries is that, my lord, why departmental.
You are
counsel
filing
is
affidavit,
anxious about
bring the
that.
entire record by as annexers.
Yes.
My lord, I'll bring that, my lord.
Lovely.
Some angry.
May it please your lordship. In the contempt petition, lordship will find the order at page 10, my lord, or 11% page 15, my lord.
Who is the concerned,
Paragraph 7, my
relevant,
lord.
relevant page?
Page 15, my lord,
Page
paragraph 7.
And what is this order? Page 17?
My lord, in this order in the repetition, my lord, the compensation cases of one of the repetition was not mentioned. Therefore, my lord, interlocutory application was filed for clarification. In the interlocutory application, my lord, compensation case of the other repetition also recorded.
Principal Secretary. Or Mr. Aishwarya. Planet. Counsel for the petitioners. Post of reason. Contempt. This contempt petition. under so and so, so and so. Is preferred. Alleging deliberate violation of the direction passed in order dated 8/2/2023 in the writ petition WPC number 6281/2021, read with an order dated 20/04/2023, passed in I civil number 474/2023. Full stop. It is submitted that the orders have been duly brought to the notice of the respondents. Full stop. Issue notice regarding for which steps by registered post PTD within 3 working days.
Madam.
Item number 3.
But just remember item number 12 was mentioned, madam. But my lord, it is not required to be mentioned, my lord, it is wrongly mentioned, madam, my junior colleague. Item number 12. It's again, I have make a mention for listing today, my lord, by my junior colleague.
May it please your lordship. Lordship, in this case, the lordship, the proceedings in respect of
Where is
the
the state council?
lordship, state council has mentioned item number 6, lordship. This is item
Ah.
number 3. Lordship, this
Now,
matter
who is there? He is to be present.
lordship. They are not there.
He is waiting for item 6 perhaps.
Lordship,
Be
otherwise,
Chaudhary.
the matter has
You
become
wait,
infructuous.
again it will be called up with 6.
Lordship, they are not similar, lordship. This has become infructuous, in fact. This matter,
want to?
lordship.
Okay, there has been withdrawn.
Lordship, the proceedings has been dropped, lordship.
Okay.
Uh,
It will do. Yes, Mr. Borua.
My lord. My lord, the proceedings in this
Reference to
matter has been dropped, my lord.
issued to you. Which proceeding has been dropped?
Lordship, the show cause notice dated,
21/12/2023.
lordship, the impute show cause, lordship.
Okay. Mr.
P. Das.
P. Das. Learned Counsel for the petition, and Mr.
H. Purva.
H. Borua, Learned Counsel representing Mr. B. Chaudhary. Learned Standing Counsel Finance and Taxation Department for all the respondents post of. The Learned Counsel for the parties have conjointly submitted that the impugned show cause notice dated 21/12/2023 has since been withdrawn by an order dated 20/02/2024. And as such, the writ petition as challenging the said show cause notice dated 21/12/2023 has become infructuous. In view of the above submission made by the Learned Counsel for the parties, the writ petition is dismissed as infructuous, full stop. The interim order passed earlier on 19/1/2024 stands accordingly recalled.
I'm observing.
A copy of the order dated 20/2/2024, placed by the Learned Counsel for the parties, is kept with a case.
Item 4.
May it please your lordship. Well, my learned friend supposed to extraction matter.
What is the case?
My lord, for nomination, my lord, nominee for transfer of the amount, my lord, in the name of the nominee, my lord.
Devotional service ISKCON Hilltop regulation. In the meantime, Nalini Kumar Chaudhary, P. Chaudhary from Watch Character Extended Responsibilities Funeral Property owned on a joint bank account. Right. Really Chaudhary. But a nominee was registered,
Nominee was not registered, Your
not registered.
Not registered. Your Lordship, what was happened? That at the time of depositing her KYC form, she has mentioned the name of Divya Jyoti. Divya Jyoti Deka, and mentioned as her son. But the Divya Jyoti Deka, who is a petitioner here, is the son of Hemchandra Deka. He is not a son of the husband of the deceased. And that is a disputed question of fact that has been.
Then what can we help if it is not registered?
It is better they should file succession petition.
Succession, or if you say that bank is in deficient, providing deficient service, you can file a ombudsman or.
The ombudsman order has been
complaint,
attached to Your Lordship.
Consumer complaint, but if there is doubt about it, then succession certificate, but I don't think writ petition is a proper remedy. If you want to, you just bring that in a form of affidavit, then.
Yes, sir.
Short affidavit will issue more notice.
Maybe, Your Lordship, but that is disputed question of.
Otherwise, the result is known.
Lordship, if it is disputed, he may file affidavit thereafter, madam.
Let us keep it in a motion stage or notice.
Just Your Lordship may keep it in motion stage because
Lord,
there is
that will be
nothing, we
better.
will file it within 2 and 3 days, Your Lordship.
Let us issue notice then.
Yes.
Heard Mr. G. Uddin, Learned Counsel for the petition, and Mr. M. Sharma, Learned Counsel for the respondent bank. Full stop. Mr. Sharma, Learned Counsel for the respondent bank, has submitted that he has received the necessary instruction and affidavit in opposition will be filed within 10 days time. Full stop. Let notice be issued. Come on. Full stop. The notice is made returnable on
27/3.
not required. All are represented.
Yes, my lord.
Yes, Your Lordship, all are represented.
No point then, no. Make it 4-3.
4-3.
Will it be all right?
Sole respondent. Yes, Your Lordship.
Sole respondent.
Yes, sir.
And after 4 any day, madam.
After 4, any day. 6.
6.
Okay. 6-3. As Mr. Sharma has already appeared and accepted notice on behalf of the sole respondent, no formal notice need to be issued. However, an extra copy of the writ petition shall be furnished to Mr. Sharma, Learned Counsel for the respondent bank by Mr. Ziuddin, Learned Counsel for the petitioner by today.
Today, madam.
Highly appreciated.
May I please, Your Lordship? My Lord, in this case, my Lord, I have filed one additional affidavit, my Lord. My Lord, will kindly have a look at page 50 of the running page, 50. And the 51 is the relevant page, my Lord. Lordship will kindly peruse para 2 and para 3, my Lord, of my additional affidavit.
Para?
2 and 3, my Lord. Right from page 51, my Lord. It will be separately, but not I can say.
Mr. Counsel, there is no whisper that there is a title suit pending.
My lord, that instruction I have not received, my lord.
Ah.
If something is there, my lord, let them file their affidavit. I'll
The
clarify. it, my lord.
government
I'll
is
clarify.
saying now,
I'll clarify it, my lord. Let them submit their, my lord, affidavit, my lord. I'll clarify it, my lord.
the direct purchase method to go to now. You have already submitted indemnity bond also, Form C also.
My lord.
Then why making a U-turn? You have preferred this repeat.
My lord, and as per the notice, my lord, which was received, served upon us, my lord. The dark number and pattern number was shown as, pattern number was shown as 28, my lord, page 45, my lord. Lordship will kindly have a look, my lord. In excess 7, my lord. And dark number was shown as 70, my lord. Page 45 and excess 7 of my read
Contact
petition.
number 70, pattern number 28.
28. Now, my lord will kindly have a look at page 47 and extra 8, my lord. that was wrongly listed while making the assessment of the list. Yes, assessments list, my lord. Page 47, annexure 8, my lord. At serial number 29, the name of my father appears, Sahid Chaudhary, my lord, and the Dag and Pata number has been wrongly shown as 69 and 109, my lord. And the amount is also, my lord, very meager amount, my lord. For 11 lachas of land, 1,55,000 only, my lord. In comparison to others, my lord. Very meager amount.
Where is Sahid Chaudhary's name in the Jamabandi?
Yes, my lord. His name is there, my lord. Right from, my lord, page 33, my lord. The Jamabandi copies in the name of, my lord, Sahid Chaudhary. And in annexure 5 also, my lord, the name of Sahid Chaudhary is also there. Page
Page,
40 also, my lord.
page, first page.
First one is at page, my lord, 33, my lord. That is the type copy, my lord, translated and type copy. Sahid Chaudhary's name appeared at serial number 24, my lord, in the
Serial
vernacular.
number
24, my lord. In vernacular, lordship will
24.
find at page, my lord, 36, my lord.
24.
Page 36, my lord, vernacular.
20, 24, 20, serial number 24,
24, it was there, Sahid Chaudhary.
page 36,
Page 36 is the vernacular.
page 24, 36, page 24. Sorry, serial number 24 is Mosha Porhana Begum.
My lord, serial number 24, I'm sorry, my lord.
Huh?
Serial number 28, my lord, it is. in
That has
English.
been struck out.
Struck out because they have, my lord, legally acquired the other petitioners, my lord. He was no more, my lord.
Where is the relevant entry?
Relevant.
Why
entry.
his name has been struck out?
Yes, my lord. The
There should
other,
be relevant entry on the right side.
yes. The next, my lord, Jamabandi copy is there, my lord.
No, where is the entry on the right side?
Yes. Find it. 6, my lord, remarks column.
Huh?
Remarks column is at 6, my lord.
Saw.
6.
That was in 1992. His name was included. Now, where by which entry his name was excluded?
Yes.
You have presented one side of the story, and why his name was struck out.
But he was no more, my lord. I have
No
next the
more,
death
but
certificate. my lord.
Somebody's name has to be deleted or struck out.
Yes.
There must be some remark.
My lord, annexure 6, my lord, page 42. That
Now,
is
why
all.
in this Ramamandi that is running from page 34
Yes, my lord.
to 39,
My lord.
where is the right side remark column
My lord. That I'm trying to find out.
showing the reason as to why his name was struck out?
I'm trying to find out, my lord. I'm not getting it. It's a long, my lord.
If you are trying to find out, then how can the court will find out? If you are still trying to find out,
But in annexure 6, my lord, page
Why
42, my
you are
lord.
going to Annexure 6 time and again? I'm asking you,
My lord.
why don't you show it from Annexure 4?
Yes, my lord.
Why you are going to Annexure 6 time and again? Because this Annexure 5 also, that was of 1996. This is also of 1996.
Yes.
Then here it is apparent that his name is struck out. Annexure 4,
Yes,
right?
my lord.
And if you examine, go on examining, then this document contains right hand side remarks up to 2022.
Yes.
So
In my lord, page 35 also, my lord. In the remarks column at my lord, go, my lord. The name of my lord, that Sahej Chaudhary is also there, my lord.
that I know, but why at page entry
Yes, my lord.
28, his name has been shown, deleted.
I'll clarify it, my lord. Lordship will kindly allow me sir, my lord, some time, my lord, at least a week time, my lord.
Because now this is throwing doubt.
I'll clarify it, my lord. Definitely I'll clarify it, my lord.
Because the right hand side column remarks
My lord.
are up to 2022.
Yes, my lord.
And in the meantime, his name has been struck out.
My lord.
So there must be some reason for striking out his name.
And my lord, regarding why I'm referring this, my lord, annexure 6, my lord, Lordship. if you
Annexure
like-
6, it contained entries up to only 1996,
My lord.
Mr. Counsel. And this Annexure 4
My lord.
contains entries up to 2022,
Yes, my lord.
where his name was struck out.
My lord.
So he showed his name.
My lord.
And there is some doubt now, because there is a title suit,
I'll clarify it, my lord.
which you have not mentioned.
My lord, I have not been
You
instructed, my lord.
decided to maintain complete silence about it.
My lord, I have not received any instruction. I'll clarify it, my lord, with all respect, my lord. I'll clarify.
Don't take piecemeal instructions and making the court to labor.
No, my lord. Sorry.
This is not proper. And you have also signed an agreement also with the respondent authorities.
My lord.
But your case is that you did not sign any agreement.
I said, my lord, that my submission was that, my lord, as per notice, my lord, the assessment list was wrongly prepared, my lord. It was also wrongly prepared, my lord.
But
Showing
you did not, you say that your willingness was not.
the DAG number and PATA number was wrongly mentioned, my lord. The assessment list also, my lord, annexure 8, my lord.
Then go and make the application for correction.
My lord, I made an
But
application, my lord. My lord,
You have projected a totally different story in this before this court. That there was no willingness form obtained from you, right? Right?
Well.
Is it not?
my lord.
Huh? But they are saying you have already signed the agreement. These are quite disturbing facts. One who approaches the court
My lord.
should approach the court with clean hands.
My lord.
Suppression of fact will discourage
I'll file.
this court from giving relief.
My lord, in annexure 9, my lord, if your lordship permit me, my lord, I clarify.
Why you are making, I am not looking, I will not be looking all those.
For the
documents.
concerned authorities,
Mr. Counsel, when,
It was not considered, my lord.
when few facts are clear from the documents itself,
My lord.
your mere application will not do. If the land documents are projecting a different story altogether,
My lord.
it appears that you are not the owner of the land. You are only position, it appears.
Clarify it. my lord.
Sahid Chaudhary's name has been deleted from the records of rights. You are not showing me the reason why his name was deleted. You may be his son, but if he has sold the land to somebody else, it appears that you are in possession of the land. Whether your position is authorized or unauthorized, there is question.
Lord, I'll clarify this time. Lordship will kindly allow me some time, my lord. If it's-
Otherwise-
leave it to your lordship, my lord.
You'll be visited with serious consequences
I'll clarify.
for misleading this court.
No, my lord, I'm not trying to mislead this court. my lord.
Right.
As per instruction, we would have.
You said you did not submit consent form, whereas you had already executed agreement. If that is the situation, well, you should have apprised the court. This separation of facts is not very appreciated. Zaid Hamad Learned Counsel for the petition has paid for listing of the case after a week in order to complete his instructions. Full stop. MS S. Borua. Also heard MS N. Borulwe. Learned it. Standing house. Revenue Department for the respondent number 1 and MS S. Borua Learned Junior Government Advocate Assam for the respondent number 2, 3, and 4. MS Borua has placed a communication bearing number ECF under memo number so and so, issued under memo number so and so, dated 20/2/2024 of the additional deputy commissioner Hojai, my address to her. In the said communication, it has been conveyed that the petitioners has submitted signed copy, had signed in Form C, within bracket, agreement with the interested persons other than the landowner. Bracket close, along with indemnity bond. Lays the case. Issue notice returnable in 3 weeks. As so and so appeared, except no formal notice. Extra copy you need to work with it. It is all observed that modifying the earlier interim order, it is observed that the process of acquisition shall be strictly in terms of the notification dated 7/3/2020.
But
Hmm? Oh. Whereby the scheme, land acquisition through direct purchase by way of negotiated settlement for all departments in the state of Assam, unquote, has been notified.
I know.
Yes, sir. Then we'll issue notice.
Lordship.
Hard, Mr.
P. Das, lordship.
Pidas and counsel for the petition. And Mr. H. Borua, Learned Standing Counsel of Learned Counsel, representing Mr. B. Chaudhary, Learned Standing Counsel, Finance and Taxation Department for the respondent number 1, 2, 3. Mr. Borua. Learned Counsel appearing for the respondent authorities have submitted that. He would need further 2 weeks time to obtain instructions in reference to the order dated 9/2/2024. Let notice be issued, so that notice is made returnable on March 2003, 2024. As Mr. Borua has appeared and accepted notice on behalf of all the respondents, no formal notice, extra copies within 2 working days. The interim order passed earlier shall continue till the next.
Highly approved, my lord.
May I please your lordships? My lord, the matter relates to, my lord, not holding the AGM come elections, my lord. My lord, what has happened from the last few years, my lord, there was no regularly constituted board of directors, my lord. As a result, my lord, one-man committee had
The
been constituted.
petitioner is involved in that Fashi Bazar.
My lord,
Fashi Bazar land.
my lord, that matter, my lord, land disputes.
Lordship.
Fashi Bazar.
My lord, they have some
Raise the
property.
case before any other events will be.
Obliged.
Lord, that instruction I do not have. I'm sorry, my lord.
That Purbuttor.
My
lord,
lord, yes, my son. Obliged.
My senior is on legs. My senior is on legs.
Who is your senior?
Mr. Zepine.
And have you gone through this?
Yes, Lordship, I have
Yes.
gone through this.
Yes.
It is a covered case, Lordship.
Okay. What is your subject matter of challenge?
Lordship, there's a similar order is in page number 56.
Okay, similar. What is your case?
My case is, Lordship, the petitioner, land matter, my lordship.
Huh?
Land matter. Land.
Land. Land is very big word. Entire art is.
No, Lordship, the petitioner has a certain plot of land. So, Lordship, he has also, she has also applied for NOC building permission to construct the residential RCC building.
Okay.
Lordship, her name is in.
Yes.
The file number application is under Mukhyamantri Sahas Griha Nirman Ashrani in the name of Kanika Devi. Then, Lordship, there is a communication that the 2/3/23 issued by the Joint Secretary.
What does he say?
It is clarified that the notification that the 7/10/2021 will be applicable in relation forest royalty in both government department and urban local bodies for the government and private agency until the.
What is applicable? Yes, it's applicable, but what is? Why petitioner is aggrieved? You are reading here only. Madam? Third, your name please.
Airpine.
A Pang. Learned counsel for the petitioner. Mr. I. Bodhakur, learned counsel representing Mr. P. N. Goswami. Learned standing counsel, Environment and Forest Department for the respondent number 1, 2, 3. 1, 2, 3?
Yes.
MSS Sutia. Learned counsel, standing counsel.
No, my lord, I pay on behalf of P. Nayak.
Learned counsel representing Mr. P. Nayak, learned standing counsel, Housing and Urban Affairs Department. For the respondent number 4. And
Also, my lord.
Huh?
GMC. 7, my lord. GMC.
okay, standing counsel GMC. For the respondent number
4 and 7.
I go to 4 and standing counsel GMC. For respondent number 7. And who represents respondent number 5 and 6? MS S. Borua, Junior Government Advocate Assam, for the respondent number 5 and 6. First. Fair enough. The petitioner has averred that she owns and is in possession of a plot of land measuring 1 katha 13 lesses, comma, covered by Dag number 2585, Roman and KP pattern number 759, comma, situated at Revenue Village, Udalbakra, comma, Mauja, Meltola, Kamrup Metro, District Kamrup Metro, comma, sorry, Guwahati, comma, District Kamrup Metro, subject. So it is a case of the petitioner that the petitioner is desirous of constructing a residential RCC building on the subject plot and has accordingly sought for, has accordingly applied for building permission stroke no objection certificate. Wide file number stroke application number under the Mukhyamantri Sahaj Griha Nirman Asani. The petitioners have heard the petitioner submitted that the petitioner intends to construct the proposed residential RCC building by obtaining materials from open market by paying all due necessary taxes, etc. But it has been informed to the petitioner that the building permission stroke NOC for construction of the proposed residential RCC building would not be granted unless the petitioner deposits forest royalty
Yes.
in terms of a decision taken by the Mines and Minerals Department, Government of Assam, contained in a communication bearing number so and so dated 2/3/2023. So 2.1, 2.3, 4, 5, 6. Okay, issue notice returnable. 4 weeks. Shall not insist.
Name of the day some may be reflected
Okay.
in that copy.
Name
That
of
copy also not, sir.
learned government advocate Assam be reflected in the respondent side in causes. Extra copies by 2 working.
Lordship. Lordship, there's
Ah.
interim.
Interim prayer allowed.
May I please your lordship? Lordship, matter may be passable for the time being, my lord. Additional advocate general will appear, my lord, in this matter. He's on legs, my lord. And it's a similar matter, my lord, with supplementary list item 53, my lord. Same issue, my lord. 53.
Okay.
Both matters may be taken up together, my lord.
My lord.
Oblige.
May it please your lordship. Well, the petitioner before your lordship is registered under the provisions of service tax, my lord. Your lordship peruses the registration certificate, my lord, it's necessary, page 34, my lord.
50?
Page 34, my lord.
34. Yes. Yes.
My lord, this is a registration certificate issued by the Central Board of Excise and Customs, my lord. And if your lordship peruses just in the middle part, my lord, types of services, my lord. What are the types of services that the petitioner renders? These are 2 types, my lord. Rent-a-cab scheme, operator service. And second is, my lord, transport of goods by road, my lord. Now, my lord, when these type of services are rendered, my lord, insofar as rent-a-cab is concerned, my lord, then the tax which is payable, that is, my lord, 40% of the receipts which is, my lord, is terms of a central government notification, which I have annexed it to the writ petition. Lordship will find that as annexure 2, my lord. Page 38, if your lordship, annexure 2, my lord, it starts from page 35.
What is this notification?
My lord, this is a notification in which
This is
service
all conferred under 93 of the Finance Act
of the finance section.
and its appreciation of friends. The central government being satisfied that it is necessary in the public to do exempts. Civil service of the description, column 2. Column 2. So much of the statistics available on the section 66 as is in excess of the service calculated and available is different from the right column. What is the meaning of this? Page 38?
Lordship, now page 30, there is a percentage, my lord. Lordship, what is the percentage that will be paid as tax, my lord? About
Which entry? Entry number?
Lordship, the case is, our petitioner's case is applicable. First page 37, my lord.
First 37.
My lord, serial number 9.
Serial number 9.
Renting of any cab
Hmm.
is 40%, my lord.
Meaning thereby?
Thereby the 40% of the, my lord's receipts will be taxable, my lord.
Okay.
And in same thing is finds place in page 38 also, my lord, serial number 10. Transport of passengers with or without accompanied belongings, a contract carriage, lordship, contract carriage, other than motor cab, my lord, is also 40%.
Okay.
Now, my lord, this is one type of service which is rendered by the petitioner. Insofar as the second service is concerned, my lord, which is, my lord, transportation of goods, my lord. Now, that modality is governed, my lord, by section 66B of the, my lord, the Finance Act, my lord.
Hey, any second. Yes.
Section 66B, my lord, reads as such, my lord. Select start, my lord. There shall be levied a tax hereinafter referred to as the service tax at the rate of 14% on the value of all services other than those services specified in the negative list, provided or agreed to be provided in the taxable territory by
66B.
66B, my lord.
Okay, there shall be.
Your lordship, yeah. Shall I read once again, my lord? There shall be levied a tax hereinafter referred to as the service tax at the rate of 14% on the value of all services other than those services specified in the negative list, provided or agreed to be provided in the taxable territory by one person to another and collected in such manner as may be prescribed. Now, my lord, the negative list, it is in, my lord, 66D. The petitioner's operations comes under, my lord, 66D A3, my lord. The negative list is comprised of following services, namely the 3, my lord. Roman 3, small Roman 3, transport of goods, my lord. So these are the two services which are rendered by the petitioner. On top of it, my lord, I respectfully beg to submit that if the transport of good is done in respect of defense, my lord, for army, this will come in later, my lord, in the case when I proceed with my argument, then that service tax is altogether exempted, my lord. If the service is rendered to the army, my lord. Now, my lord, for the assessment, there was an assessment, my lord, done under the service tax, and that was for 14-15 to 17-18, my lord. For 4 financial years, my lord, assessments were done. So it is the case of the petitioner, my lord.
So you are served with demand notice.
Demand notice. I'm coming to
let
that.
us-
I'm coming to that factor, my lord. I'll place that fact before your lordship. Prior to that, I just want to submit, my lord, during those assessment years, petitioner had rendered service only to the Indian Army and that too was through a contract, my lord, which was pursuant to a regular tender process, my lord. And to this effect, my lord, the petitioner has maintained ledger accounts, my lord. He has audited balances. The work orders are also there. And on top of it, my lord, the concerned authorities of the army has certified this fact, my lord. If your lordship peruses, my lord, page number 11, my lord. My lord, are our pleadings, my lord. Page 11, para 8 are our pleadings, my lord.
Okay.
I'm just reading out only one paragraph on the pleadings, my lord. That is, what is the pleaded case exactly?
Paragraph?
Para 8, my lord. Page 11. That the petitioner begs to state that apart from the service of, this is one of first, was the rent-a-cab service, then, my lord. The other service provided during the period was providing of transport of goods services, and that services was also mainly provided to the Indian Army under contracts awarded to person to a retail tender process. The service of transportation of goods by road falls under negative list prescribed in section 6, which I have just referred, my lord, and therefore no service tax is payable in the said service. Now, my lord, what has happened? The petitioner was served with a so-cause notice. This so-cause notice was, my lord, drawn on the basis of, my lord, petitioner's own income tax return, the disclosure which he makes under in Form 26D, my lord, about the total turnover. From this, the taxing authorities gathered the information, and he was so caused. In this so caused, my lord, in the assessment proceedings, he participated, my lord. And he had shown all the records that the service was rendered to the Indian Army. So these are exempted services. And whatever is leviable under the for rent-a-cab service, that is only 40%, which tax he has already deposited. The deposit challans are in record, my lord, on record before your lordship. Now, my lord, be that as it may, my lord, the assessment order went against the petitioner.
Where is the assessment order?
My lord, assessment order in original is, lordship, page 241. 241, lordship. It is from 241 to 264, my lord. They call it the order in original, my lord. This is nomenclature, the order in original. Now, my lord, the findings, the vital findings, my lord, if I am to take your lordship to verify.
Now, this is 28/3/2022.
Lordship.
Now, this is an appealable order.
True, my lord. We preferred an appeal. Now, why I am before your the lordship in the writ proceeding, my lord?
Let us see the
confess that
fate of the appeal.
Lordship. Now, what has happened, my lord? I preferred an appeal, my lord, before the appellate authority. The appeal with lordship, pre-deposit of whatever requisite pre-deposit is required, 8 lakhs and odd amount we deposited, my lord. The appellate authority, my lord, I am aggrieved by the order passed by the appellate authority, in which, my lord, in a very perverse manner, it was held that I had not participated in the hearings, although I had, my lord, 3 dates were fixed. On 2 dates, I had placed adjournment applications which were taken on record. But thereafter also, even then it was recorded that I had not participated in the proceeding. And on the final day, when I had filed my written submission, even on that date, my absence was shown and it was summarily rejected, my lord. Or everything which was the finding of the, my lord, the assessing authority was simply upheld. I am just taking your lordship to the relevant.
Where it is recorded that you were absent?
Lordship, yes, lordship. 283, my lord.
No, in the
Lordship,
order in
page
appeal,
two.
order in appeal.
Order in appeal, lordship, 328, lordship. 328, if your lordship, this is the relevant portion of the order in appeal.
328.
328, lordship.
Okay, which part?
Paragraph 11, lordship.
And how do you substantiate that this is you are present?
Yes, I will show your lordship.
Adjournment is no presence. Adjournment is at your request.
My lord, personal hearing of the case was fixed on 23/5/2023. 15/6/2023 and 18/7/23, wherein nobody on behalf of the appellant appeared for hearing. My lord, this is a incorrect finding, my lord.
Okay, what did happen on 23/5/2022?
I am showing your lordship. My lord, if your lordship comes to now page 281, my lord.
Tell me.
My lord, I filed beforehand, my lord, I filed a adjournment petition.
Okay.
Saying that on that date, particular date fixed for
That
hearing.
is no prejudice.
Lordship,
That is no prejudice. You have sought for adjournment.
lordship.
Okay, then what happened?
Then on the second date also, I sought, asked for adjournment.
Okay, which page, which page?
My lord, that is in page 282, my lord. 281 and 282 are my adjournment petitions. My lord.
Okay,
Now, my lord, 283. Page 283, my lord. On the last date, my lord, I filed my written submission, my lord. If your lordship peruses, there is a seal. In all the days, there are sealed. Those are received by the office with acknowledgement, my lord. If your lordship annexure 14.
page 2.
283, my lord.
Okay, this is what? Written submission.
Your lordship, yes. 18th of lordship will see the receipt seal of the authorities, my lord, concerned authorities.
Hmm.
My lord, 18th of July 2023, my lord. I was present there, my lord.
Any other ground?
My lord, this is the only ground I have taken, my lord. So this is my lord, violative of natural justice. I should have been given an adequate opportunity. I would have proved my case. Yet at the end of the day, my services are exempted, my lord. On any day I can show. The army authority, there is certificate by the army authorities also. And more importantly, my lord, army has duly certified that they have not collected any services.
Yes, so for this recording of this statement, we are not about 23rd of May or 15th of June.
Correct.
On those 2 dates, he sought for adjournment. And the gap is quite okay. Or if he had sought adjournment on 23/5/2023, the next date was fixed on 15/6/2023. And on that day also he had sought for adjournment. I don't think that is a case of prejudice. Enough time was given for the next date. Then again, up to 18/7. Only thing is 18/7. I don't think the other 2 dates. I don't think. You sought for adjournment.
Whatever the records say, my lord, my duty is to, my
18/7.
lord.
It was said that nobody on behalf of the appellant appeared for
But
hearing.
that-
I don't know what is the exact situation, but 283 reflects at least there are written submissions have been submitted. Then when is the order in appeal?
My lord, this is the order in appeal.
Date.
8/6, my lord.
8/6. Then there should be 8/6?
No, not 8/6. I'm just.
8/8/2023 page
317.
8/8.
Page 317.
Then if this 283 is correct, there should be some reflection of it in the order in origin appeal.
That is not there.
That is not, if that is not there, then at least whether his personal hearing should be afforded or not, that is one matter.
That should
But
have been
if
considered.
it is reflected
That should
that
have
on
been
18/7 they have received,
Not.
at least there should be some consideration in the order in appeal.
Not. Correct. Lordship.
Take your instruction.
Lordship, otherwise Lordship may remand back the matter to the.
Take your instruction.
Lordship.
If you have the instruction, then remand, I'll remand.
Lordship, maybe next week. Lordship.
If you have the instruction that method, then
Lordship.
if you have no instruction, then that is different.
Because first time it has come.
So I'll give you opportunity to find out whether that written submission was received on 18/7/2023. And why you have come so late? That is one issue, Mr. Rahul.
That is there, my lord. But, my lord,
You have to address what is the statutory appeal period?
3 months, my lord.
3 months.
3 months, my lord.
That was in August.
August.
When it was communicated to you? August, September, October, November, December,
the
January, February. You are in February. We are in February.
Okay.
6 months.
Some, but still, my lord, the fact.
No, show me, because there is decision of the Supreme Court that if there is statutory period. And instead of statutory period for appeal, right? 3 months. But instead of preferring the appeal, the SSC has chosen to prefer a writ petition under Article 226. Am I clear?
I too, my lord. I-
Then that writ petition must be within the statutory period of limitation fixed for appeal. How do you overcome that?
Well, to that effect, if necessary, I will also.
Even if you made out a case, because ultimately Supreme Court has said,
Yes. Cannot-
even under Article 142, we cannot. So, High Court, please stop entering writ petition. If the writ petitions are filed beyond the period of limitation fixed for filing appeal, and the SSC has chosen not to prefer appeal, and after statutory period of limitation, filing writ petition.
My lord.
What do you say about that?
My lord, if my prayer is gone into my lord.
No, prayer will be,
My lord.
question comes
Yes. true,
about
my lord.
entertaining the writ petition.
My lord, I have not come before your lordship as a appellate. forum, my
That
lord.
is what?
My lord.
Which a ground. This can be a ground which can be taken in appeal also. Mr. Rahul,
Understood, my lord.
which you have taken in a writ petition.
Lordship.
Had it been a case of lack of jurisdiction, yes, that is a different matter altogether. But yes, like this ground can be taken, that violation of the principles of natural justice, that can be taken in a writ petition. Okay, quite well. But at the same time, some restrictions have been placed that this should be taken within the statutory period of limitation. Why you have waited for 8 months? See, Mr. Rahul, we are
But to
we
that
are
effect,
also-
but to
we
that
have
effect,
to also,
my lord,
in a writ petition also, where the
parameters are there.
statutory regime is there
Lordship.
to entertain a writ petition, we are also bound by some parameters.
Lordship, true. Well, to that effect, I will.
Show
file a-
me that bar can be overcome in a writ petition on the ground of principle of natural justice. Otherwise, it is very difficult. Yes, what do you
Yes.
say? What is the position of law?
Lordship, we have to file under 86 of Finance Act 19.
Otherwise, start appeal.
Yes.
I think there is no period of limitation.
90 days.
3 months,
3 months.
but it is condonable. It is
Not condemned.
no outer limit.
There is no, this is the outer limit, Lord.
No.
3 months.
3 months, then see,
Lordship,
85 or 86?
86.
Let us see 86. See, Mr. Rahul, I am also not
Understood.
fully conversant with the law.
Appeals to appellate tribunal, my lord,
86.
86.
Let's start perhaps.
Lordship.
So now see the condition provision.
Paragraph 1 is, in 1 it is mentioned, Lordship.
Subsection 5. There is no outer limit perhaps. If there is
Appellate
amendment, I
tribunal
don't know.
May.
If there is amendment,
There is no outer limit.
Huh?
There
No,
is no outer limit.
Outer limit.
It is condemnable.
Then why you have not approached? Even now you can approach.
My lord, here is a situation where, my lord, if my appeal is heard in the proper perspective, the same person I will succeed.
These are also.
And the appellate order, my lord, is prima facie, my lord, it shows there is violation of natural justice.
But entering a writ petition is also, you make out a proper case. Yes, this is a case.
Lordship.
Okay. I can find out, but show me the other law. What are the authoritative pronouncement?
Lordship, yes, there is a Like to rely upon.
In respect of Cestat, yes.
Okay, same point has been raised in item 36. Today,
My lord, in
Senior
mock-
Advocate Vidas is appearing.
No, that is a different matter.
No, no.
That is violation of nature just at the stage of, okay, that is. They have,
Point probably same regarding.
no, no, at least
Okay.
here,
Lots.
here, I don't know that we are not on the merits of the case because we have not delivered anything.
No.
But here they have made out a primacy case
Yes, that is there.
that on 18/7/2023, they have submitted a written
That is not-
submission and the authority had acknowledged the receipt of the same.
Yes.
But there is no reflection.
Yeah, Lords, correct. Lord.
That is a case otherwise. You,
In that
Data
case, it is
instruction.
different. That,
but question is that whether in such situation, by exercising 226 power, this kind of writ petition can be entered in by passing the statutory
remedy.
regime. Whether there are, Mr. Rahul, proceed on.
one authority I have collected, my lord. May I just place one judgment, my lord? in this Supreme Court. Mogot Sugar Energy Limited.
Mogot Sugar, I know. But question is the other point. The other point that you have come here after 8 months. Find out authority on that.
My lord,
Mogot Sugar, that is all right.
That is,
my lord,
Same thing as Whirlpool and
many judgments are there.
Hermans. Same thing as like that. But the other one, that entertaining a writ petition beyond the period of limitation,
But my lord, since there is no outer limit in the
show
statute,
me some. Otherwise,
since there is no outer limit, had it been, my lord,
no,
yes.
show me some, even
My
if we
action,
exercise.
had there been, my lord,
No, there may be authorities either this way or that way.
I'll check up, my lord.
Otherwise, it will, because the case which I am saying, on the basis of which, that if this kind of thing are going to be entertained, thousands and thousands of the writ petitions will be filed every day.
Yes, Lordship, that is there.
So this is the, entertaining a writ petition is one thing. But entertaining this kind of thing, then next day thousands will be filed. That is the worrisome factor, Mr. Rahul. That is what has been observed. That this otherwise, at one point, this proceeding must come to it.
My lord,
This way or that way, rightly or wrongly, whatever it is. So come up with that authority if something is there. Really, your violation of principle of natural justice is so that every statutory
My
bar
lord,
can be overcome.
but remedy will be more efficacious, my lord, also. If I
If
get a
it-
remedy
that-
from, because here
It
also,
is more adequate. It can go into the questions of act. Let us have the person from Mr. Kyle. If he disputes, then it goes into the disputed territory. Then writ petition goes. So I am giving you the opportunity, let him
Next Tuesday.
next Tuesday or Wednesday.
Wednesday.
I think it right, like quiz. Okay, we'll keep it on 28th Wednesday. Okay. Are Mr. G. Rahul, Learned Counsel for the petitioner, and Mr. S. C. Kal, Learned Standing Counsel. CGST for the respond number 225. What is your explanation?
My lord,
Writ petition about the delay.
my lord, I'll file an additional.
No. We are in a motion state. Now don't fill up lacunas. Will not permit.
No, there was-
Mr.
There was some family problem, my lord.
Rahul, Learned Counsel for the petitioner has submitted that during the appeal proceedings, the petitioner has submitted written submissions on 18/7/2023. Full stop. But in the order in appeal passed on 8/8/2023, there is no reflection that the appellate authority considered the written submission filed on behalf of the petitioner, whereas the written submissions, the written submissions, a memo, a written submission was duly acknowledged by the, where did you submit? Let us see the office
My lord, on the say, on 18/7 itself, my lord.
page.
Page, my lord, 300, 283, my lord, 283. 283, my lord,
283.
283.
Was acknowledged by the office of the appellate authority on 18/7/2023. Post of Mr. Kyle Leonard, standing counsel, CGST has submitted that he will obtain instruction as regards the submission of the memo of written submission, and has sought for posting of the case on next Wednesday.
My lord, just at the cost of interrupting, I apologize, my lord. 305, the paper book was also submitted on the same date with seal endorsement is there. Page 305, my lord. The paper book document, my lord.
Written submission, as well as paper book.
Paper book.
Huh? Just you find out that that overcoming that violation of principal justice may be a case, but the other
limitation,
that constitutional power can be exercised. Otherwise, Supreme Court has said under Article 142 also, because that in that case, initially Supreme Court passed an interim order entertaining a writ petition, which was filed beyond the statutory period of filing the appeal. Then at the final order, said we did the wrong interim order, so and so, so and so. Because on the view that this must come to an end. This way or that way, somebody will suffer, but proceedings should come to an end. When a statutory period of limitations are provided in the statute, then they have to act on that basis. So this is one stumbling block which
I'll try to
you have to overcome.
Obliged.
Item number 11.
May I please, your lordship.
Yes.
Petitioner is the owner and in possession of the land 3 bighas 3 kathas 7 lessers lordship at the Bankakata place under Soigar Revenue Circle, your lordship. And on 24 April, your lordship will find at page 23, your lordship will find Annexure B. He filed an application before the circle officer revenue.
For what?
For demarcation of his land, your lordship. For demarcation of his land.
Now everything has to be online nowadays, Mr. Bora. You are in old age.
Yes, my lord. Actually, what happened thereafter, because of the incompatible season, as per their version, they could not go to visit the field, and because of that, they could not demarcate the land. Thereafter, your lordship, on again 10/11/2023, page 25, Annexure C. He filed another application referring to the earlier application dated 24/4/2023, your lordship. Again, he requested before the competent authority, lordship.
Take your instruction, otherwise we are not entering a demarcation writ petition.
Thereafter, your
We do
lordship.
not entertain, Mr. Bora, demarcation writ petition normally, but you take instruction on this basis.
Yes, my lord, page
29,
27.
29, whether anything has been initiated by the circle.
Lordship, one more document is there at page 27, Annexure D. He approached before the deputy commissioner.
We are only interested in this letter.
Yes,
Your
my lord.
application, we are not interested, Mr. Bora.
Yes, my lord.
Only in this letter. Otherwise, it is demarcation exercise has to be go through the proper procedure.
Yes, my lord.
Nowadays,
Annexure E, your lord.
without submitting an application without the necessary fees is no application at all. Have you understood?
Yes, yes, my lord. Annexure is that letter is there. Come.
Only this was. MS Borua, can you take instruction
Yes, Lordship.
from the circle officer whether any process has been initiated, any case has been registered
Yes, sir.
for demarcation in the meantime. Otherwise, his application is not through proper procedure, as I could see. MS heard Mr. Lee Bora, Land Council for the petitioner. Circle officer from whom?
Soigaon Revenue Circle.
Soigaon.
Yes.
Yes. Because first, instruction from Deputy Commissioner will not
Yes, Lord.
serve any purpose.
Nothing.
Miss G. Hazarika,
Correct one, number one.
Learned Standing Council, Revenue Department for the respondent number 1. Miss S. Borua, Learned Junior Government Advocate Assam for the respondent number 2 to 4. Full stop. It is a case of the petitioner that he is the owner of a plot of land measuring 3 bighas, 3 kathas, 7 lessas, covered by DAG number 413 and KP Patra number 90, situated village, revenue village Bangakata. Bangakata.
Yes, ma'am.
Moja Soigaon, Ponthon, District, Kamrup, Assam, subject. So, according to the petitioner, he submitted an application for demarcation before the circle officer, Soigaon Revenue Circle, when no process was initiated for demarcation of the subject plot, he submitted an application before the Deputy Commissioner, Kamrup Metro, ventilating his grievance, full stop. On the basis of the said application, Deputy Commissioner, Kamrup, provide his communication bearing number so-and-so, page 29, dated 13/12/2023. Wrote to the circle officer, Soigaon Revenue Circle, to take necessary action as regards the matter of demarcation. Necessary action as per provision of law. Also, it is a grievance of the, it is still a grievance of the petitioner that the circle officer revenue, Soigaon Revenue Circle, has not initiated any proceeding for demarcation on the basis of the application of the petitioner, post of Mr. MS Borua, Learned Junior Government Advocate Assam, has sought for listing of the case after 10 days in order to obtain instruction as to whether any proceeding has been initiated for demarcation by the circle office. From the circle officer, Soigaon Revenue Circle, list the case on.
All right.
Item number 12.
May I please your lordship, my lord. Here is the case, my lord. The petitioner is in possession of a railway land, my lord, over railway station Guwahati, my lord. What had happened, my lord, since last 30-40 years, my lord, he is occupying the plot of land and carrying out the business activities, my lord. Then your lordship will find annexure B, my lord, sorry, C, my lord.
C.
Page 21. The representation were filed before the railway authorities to consider the land of the petitioner to give license to occupy the land, my lord. That is, my lord, Principal Chief Engineer returned to the senior Dan Maligao on 2/11/06, my lord. Your lordship will find 1-1, my lord. 1A Dan and 1-2 IOWs with other subordinate staff should be nominated.
You are reading from page?
Page 21.
Which part you are reading?
Yes, my lord. Third paragraph. 1, my lord. 1-1.
Okay.
1A then and 1 or 2 IOWs with other subordinate staff should be nominated specifically for the purpose of making
assessment of shops, schools, etc. run by private organization on railway land. These assessments should be completed and reports submitted by 15/12/06 covering the entire jurisdiction of Senior Dan Maligaon. The area occupied by such establishments should be measured and compared with the authorized area, if any. In case any agreement exists, the same can be mentioned. Charges leveled and amount paid by them, if any, can be mentioned. If the shop school is totally unauthorized, the same can be mentioned. Based on the actual measurement and as per the actual.
Sinha, it appears that was followed by one eviction notice.
Yes, sir. Yes,
By
ma'am.
the estate
Yes, that,
officer
yes, that process.
in the year 2012.
Yes, ma'am. Yes, madam. Yes, madam.
If it
Yes,
is
madam.
correct.
Yes, madam.
Page 28, Annexure F.
The order, the state officer has passed the order, my lord.
No, eviction case number so and so.
Yes.
Is 28.
Yes, 28.
Under subsection 1 of section 5.
There was appeal filed.
Subsection 5. Then.
Appeal
what is it?
filed.
Okay, this is the eviction order.
Yes, sir.
So there, that was preceded by notice perhaps.
Yes, my lord. So
Under subsection 2, okay, section 4 notice is at page 27.
yes, thereafter
Then
appeal filed, my lord.
Eviction case. Then
Appeal filed.
appeal file.
Appeal was dismissed.
Appeal was dismissed.
Dismissed, my lord. That is your lord.
And everything gets buried.
Yes, my lord.
All this 2006 letter gets buried under the appellate order.
Yes, I'm coming. I'm coming, my lord. Thereafter,
Now start from appellate order.
yeah, thereafter writ petition filed, my lord.
That was dismissed.
No.
Appeal was dismissed.
Appeal was dismissed. The writ petition filed, my lord.
Okay.
Then the honorable court, considering that the aspect which I have read just now, my lord, that what the honorable court has observed, my page 44, my lord. Or we may start from para 9, page 46.
First thing, otherwise, it has been held settled. The repetition was not maintainable.
Now, I am coming on my lord,
Otherwise,
Yes.
but it has been entered in okay.
yes, page 46, my lord, para 9. Para 9, my lord. May I read, my lord?
I think you should also read first few lines of page 46.
Yes, para 9.
No. Before that, you read page 46, first few lines of last few lines of paragraph 8 also.
Yes,
It will
my
be
lord.
better
yes,
to understand everything.
yes, sir. Yes, my lord.
That page 46.
Uh,
Now, as it is an admitted fact, as could even seen from the reply so submitted by the petitioner before the estate officer, under such
That's
circumstances, this court finds
Yes,
no infirmity in the orders
Yes,
passed by
12/6/2012.
the estate officer against the petitioner as well as also the common judgment. An order dated 10/3/2014 passed by the learned so and so. So
Yes, my lord. Yes.
affirm.
Yes, my lord. Yes, I'm coming. I'm coming.
No, you have not come. About
Because
this fact that
the
court has also affirmed.
yeah, the honorable court has accommodated me, my lord. Accommodated me. That 9, my lord. Mr. So and so, so and so, however, submitted that petitioners have been doing their business for the last 30 years. And as per the report submitted by the officials of the respondents have been the reference to which have been supra, the officials of the respondent railways have themselves admitted that petitioners can be granted license. He submitted that the petitioners may be given liberty to submit their representation to the respondent authorities so that they may consider their representation taking into account that for more than 30 years, the petitioners have been carrying their business establishment and the entire livelihood of the petitioners as well as the family depends on the said business. This court has given due and anxious consideration to the said matter and have also perused the materials on record, which also shows that some of the officials of the respondent railways have recommended that the petitioners and similarly situated persons could be accommodated by giving them the license so that the railways does not lose the revenue. Taking into account the above, this court, therefore, without interfering with the order passed by the state officer, NF railway dated so and so, as well as also the judgment and order dated so and so passed by the learned additional district and session judge FTC number 1, Kamrup Miss Appeal number so and so, so and so, so and so. Disposes of both the writ petitions by granting liberty to the petitioners to submit representation before the general manager NF Railways, Mr. B. Sinha and counsel for the petition submit that the said representative shall be submitted within a period of 15 days. Then, my lord, taking into account the above, this court therefore requests the general manager of the NF Railway to consider a representation if so submitted by the petitioners compassionately and if permissible as per the extant rules as well as the policies of the railways, my lord. So under this, my lord, we have approached.
I read also page 52 and 53 in the meantime.
Yes, my lord. There
What-
yes,
What you are seeking?
the imping order has been passed now, my lord. That is 2 to 24, page 52.
52,
Yes.
53 I have read.
Yes.
I have read.
Yeah, there, my lord, your lordship will find the para 5.
Read para 5,
Ah.
para 6, para 7, I
Yes.
have read.
Yes, the land in question is,
Last part I have also read.
yes, the land in question has already been allotted to Railway Land Development Authority, RLDA, for commercial development for the interest of railway as well as for the people of Assam by agreement number so and so, so and so, so and so. This has been done, my lord, during pendency of the writ application, my lord. Now, in the affidavit in reply, affidavit filed by the railways, there you will find.
Mr. Sinha,
Yes.
with the appellate order, everything gets buried. Then thereafter, with the writ petition, affirming the appellate order, only thing that consider means as sympathetically. I don't know whether this kind of thing is available in law. Yes, definitely, had it been
My lord,
some right, now with the appeal, your right got extinguished.
Yes,
Now, matter was considered. And as per the extent policy, he is saying that there is no paragraph 7, please read. Extent rules and policies of the railway, there is no provision for granting fresh license or lease of the railway land under position of the petitioner private party on payment of
Yes, this
necessary
is the
fees.
contradictory one, my lord. This is the contradictory one.
As because this court, while dismissing almost your petition,
But
disposed of Mr.
Yeah, but in the last line, the honorable court says, without interfering in the judgment and order.
If permissible, as per the extant rules.
Yes, my lord.
Extant rules.
Yes, my lord.
Extant rules mane the rules prevailing on the date, not 2006, Mr. Sinha. Now he says, as paragraph 6, as per the extant rules and policies. Now show me from extant rules that your position in 2006 is still available in 2020.
But it is attributed fact, my lord. The rules means what? But here we are in possession of the land, my lord, till today.
Yes, that whoever given the you can do the case someplace else. I'm not interested to proceed further from the motion stage.
What shall I submit, my lord? The thing is that, my lord, on the
I don't find to proceed further from this stage. Anyway, Mr. Gogoi.
Lordship is already, it is lordship, attained finality lordship. In finality lordship as per statutory appeal.
You still agree to okay, you file your reply.
Lordship.
And don't say anything more. Heard Mr. B. Sinha, learned counsel for the petitioner, and Mr. K. Gogoi.
I am for all the respondents, lordship.
Learned central government counsel for all the respondents. Agree by the order dated 2/2024. Annexure J. The petitioner has preferred the read petition. Issue notice returnable in so and so as 4 weeks. As Mr. Logo has appeared accepted, no formal notice. Extra copies within 2 hours.
Item 13. Item number 13.
It's a very limited relief, my lord, that my application for taking physical possession, my lord, that, my lord, the district commissioner let him take up and pass an order, my lord, under section 14 of the SRFSI Act.
You have made some respondents also.
Yes, my lord, but I have also.
Short notice you can issue, but in the meantime, pendency of the petition shall not be a
But
bar.
if I may, if I may
Because
suggest.
otherwise,
My lord, if I may say, my lord, the borrowers as such have no right of hearing under section 14. For the sake of propriety, I have made them up.
no, but we are in a read petition.
Lordship, but perhaps your lordship
Some
may
formalities
consider,
are
my lord,
required to be made. Some formalities are required to be made.
perhaps your lordship may consider dispensing with notice at this stage, my lord, because all that they need to do is to.
You should not have made the parties.
Lord, we do not want to conceal, but previously or.
Ms. Borua,
Yes,
they
Lordship.
shall not be barred.
Lordship.
On the next date, at least,
Lordship.
we will do that.
Let them take the instruction, my lord, they
At
may
least
not.
let us go.
Lordship.
Complete the formalities.
Lordship. I have no difficulty.
District Commissioner knows not party. Oh, yes, Lordship.
Number 2, my lord.
Heard Mr. A. Ganguly, learned counsel for the petition. MS S. Borua, learned Junior Government Advocate Assam for respondent number 1, 2, and 3. The petitioner bank has approached dispute alleging inaction on the part of the respondent number 2. To in taking action, in taking steps under section 14 of the Service Equality. Is it possible for you to serve Dusty also?
We'll try, my lord.
Huh?
We'll take steps.
Okay, then issue notice returnable on 18/3.
Lordship.
18/3.
Lordship.
As MS Borua has appeared accepted, no formal notice. The petitioner shall take steps for service of notice after the respondent of 4 and 5 are registered post with AD within 2 working days. In addition, the petitioner is permitted. Dusty, compliance affidavit. Pendency of the petition shall not be a bar for the respondent number 2 and 3.
Well, it is actually 2, my lord. 3 is in a
To take
supplementary.
necessary steps on the application. Where is that?
Yes, page 31 onwards.
To take necessary steps under section 14 of the Service Act. On the application dated,
my lord, 22/09/2020.
22/09/2022 within bracket annexure 10.
10 minutes.
In respect of the
Taking physical possession.
In respect of the landed property.
Yes, ma'am. Of the private respondent number 5.
The landed property of the respondent number 5. The symbolic position has already been taken on.
Well, symbolic position taken and matter, the property has been sold. Yes, ma'am.
Has already been taken and auction process was completed on.
Well, the auction process was completed and the sale certificate issued on
Auction
1/12.
process was completed. Auction process has been completed with the issuance of sales certificate on
1/12/2023 minutes.
1/12. That will give a clear idea.
Lordship. Obliged.
Oh.
But please, Lordship. The subdivision level, advisory land advisory committee, by minors dated my lord 12/1/2015 my lord allotted a portion of land to the petitioner my lord.
Where?
In the year 1915. My lord, 2015 my lord. Page your observation page 15 my lord. And the relevant portion my lord page 18. Page 18 my lord, last portion my lord, clause 3.
Page 18.
Yes, ma'am. Clause 3 my lord.
Clause 3.
The meeting discussed the proposal for settlement of general Sorghum land measuring 15 lessons covered by DAG number 5072 of Sipsagar town under so and so in favor of the petitioner my lord. Pursuant to that my lord, the circle officer my lord wrote a letter to the deputy commissioner, page 30 my lord, fixing the my lord, calculating the premium to be paid by the petitioner. Page 30. Premium is assessed my lord, at rupees 2,25,000 my lord. Page 30. As a lordship got my lord. Then my lord, the deputy commissioner my lord by letter dated 26/2015, page 32 my lord. It's a translated copy my lord. Wrote to the my lord additional chief secretary my lord, revenue and disaster management about the my lord, the settlement of land in the name of the petitioner. My lord. Now what happened my lord recently my lord? My lord, we came to know on 24/7/2019, last page, my lord, page 45. my lord. When the petitioner my lord sought to deposit her my lord premium amount, the deputy commissioner rejected the my lord proposal for settlement. Holding it as time bar, my lord. Last paragraph. In view of the above, Dr. So and so do hereby reject the proposal as time bar.
You know, Nima Gogoi, Kiran Gogoi. Ah, read that again. I already. But পরিশোধন লাগিয়েছে শিবসাগর
Well, is my another petition was filed, my lord.
Nima Gogoi.
That was also disposed of, my lord. The petitioner mentioned in her application. Lords will find page 36, my lord.
Nima Gogoi talk. Kiran Gogoi শিবসাগর Which petition?
My lord.
WBC 5731.
Yes.
আছে নাকি Nima Gogoi?
Page 34, my lord.
What is the order in 5731/2013?
Direction was given, my lord, to consider the case of the petitioner, my lord, in terms of the settlement order. As the LSC is, my lord, recommended.
Is there any other petition?
That I do not know, my lord. That petition, I was the my lord, counsel for it.
আছে নাকি? Right. আটওয়ালা, দুটাওয়ালা। Kiran Gogoi তো? হ্যাঁ। How much lane? 15 lesser.
My lord, only 15 late.
Mr. Swagia,
My lord,
you are in serious trouble.
my lord.
You are in serious trouble. Give one to Mr. Borwal. One to Mr. Swagia. Read the first paragraph. Please read.
The present writ petition number 2 to 6 of the has been referred by the petitioner to a sale speaking order.
Speaking order, date.
Same order. For very so and so so and so. There was not informed my lord. Me, my lord.
Then you are in serious trouble now. Because it was proved or established that apart from these 15 lessas of land,
My lord.
another government plot of land measuring 1 katha 5 lessa
My lord.
under new DAG number 3083 carved out of original government DAG number 5072 and periodic pata number was already handed over to you. And that plot of land was already settled by the government in your favor.
My lord.
Once a person is not a landless person,
My lord.
then
No, my
he
lord.
is not entitled to
Yes, ma'am.
hold any land.
Yes.
Right?
My lord.
So, how much cost?
Well, let me take instruction.
No.
Why
We
they
are
have my
not
lord?
going to. We are not going to. Absolutely. Miss, have you stated anything in your writ petition about WBC 7551
No,
2019?
no, my lord.
19. Then there is no question.
I'm not informed, my lord, about pending.
That is, I'm not putting the thing to you,
My lord.
putting the thing to the petitioner. Council may be not apprised of, but
lord.
wife of Kiran Gogoi, KPM Sariali,
Yes, ma'am.
Ward number 9, Sibsagar, Post Office, Police Station, District Sibsagar. Is it the same lady?
Same person.
Yes.
ma'am. As per the order, ma'am, I've seen, ma'am. Same.
Hard, Mr. There is nothing left. Hard, Mr. Had it been some other court might not be aware of it. But this court has
Yes,
passed
yes,
this
yes.
judgment and order.
Yes, ma'am.
And that is on
By your lordship, ma'am.
1912, 2023 only.
My lord.
Very recent.
My lord.
And in any view of the matter, that delay from 2019 till date hasn't been explained anyway.
No. This has been.
This is another thing which has come out only now.
MS G. Hajorika, Learned Standing Council, Revenue and Disaster Management Department for the response number 1 and 2. And Mr. S. Borua, Learned Junior Government Advocate Assam for the response number 3 and 4. In this writ petition prepared under Article 226 of the Constitution of India, the petitioner has assailed a speaking order dated 24/7/2019, passed by the response number 3. which reaches under Annex 13. Full stop. Para, during the course of deliberation, comma, it has emerged that the same writ petition had earlier preferred another writ petition, WPC number 7551, 2019. In a whatever. Assailing the same speaking order dated 24/7/2019, passed by the respondent number 3, whereby the petitioner's prayer for settlement of a plot of land measuring 15 acres, covered by government tag number 5072, situated Shivsagar town within bracket part Roman 2, Mauja, Nagar Mahal, district Shivsagar, had been rejected. Post up. Para, the said petition, WBC number 7551/2019 was dismissed by judgment and order dated 19/12/2023. Full stop. Para, for ready reference, the relevant excerpts of the judgment and order dated 19/12/2023 are reproduced herein below. Paragraph 3, indology. Paragraph 3, 11. I have perused the statements and averments made in the present writ petition. Full stop. Upon careful perusal of the statement and averments made in this writ petition, it is found that there is no whisper in the entire writ petition about institution of the writ petition by the same petitioner, institution or writ petition, WBC number 7551/2019. In the writ petition. Mr. Soikia, and constable petitioner, has submitted that he has not been apprised of. He has, the petitioner has not informed him about filing of the writ petition, WBC number 7551 2019, and its consequent dismissal by judgment and order dated 19/12/2023. Post up. Para. It is in thus it is from the above discussion, it is clearly demonstrated that the petitioner has preferred the present writ petition by suppressing material facts and has, does, approach this court without clean hands. Full stop. In this connection, the following observations made in Prestige Light Limited versus State Bank of India reported in Insurance. Right. And KD Sharma versus Steel Authority of India Limited and others. Reported in 2008-12 SSD 1981 can be appropriately referred to. 8.1, 8.2. Kishore Samprait. 8.2. As the present petition, is found referred with concealment of material facts, as have been alluded in above, the repetition. It is found that the repetition has approached this court by abusing the process of law. Such repetition is not to be entertained, the repetition is dismissed. Yes, Mr. Borua suggests whom should be enriched.
The petitioner ought to be very clear about the previous thing, but that apart,
We are not
saying anything
about Mr. Soikia.
Yes.
We are saying about the petition. Whom should be enriched? Which body? Dismissed. Imposing a cost of rupees 25,000. Which amount the petitioner shall deposit with the registry? Tell me.
Legal service normally
Okay.
it is given.
Shall deposit with the registry of this court within a period of 15 days from today. Stop. On deposit of said amount, the registry will remit the said amount in favor of the Guwahati High Court Legal Services Committee.
I'm sorry, my lord. I was not informed.
You are not informed, but this kind of petition is not to be encouraged.
My lord, obviously,
And similar kind of petition.
my lord.
She is enjoying one,
Yes,
government
ma'am.
has given her
Yes.
benefit,
Yes, ma'am.
1 kata 5 lesa.
Yes, ma'am.
She is occupying another government plot of land.
That cannot
I
be.
remember now, she is running a restaurant there,
Maybe.
hotel, government plot. Once more and more.
That cannot be. Obligable.
Also, the petitioner also had purchased 10 lessons of land. And in Mission Bosundara 2.0 Lordship, he had applied in the portal Lordship. Lordship, he was not provided any information. Thereafter, he filed a first appeal before the district commissioner on 30/10/2023. And after exhaust of the statutory period of 60 days, he filed a second appeal before the RTPS commission. But till that, Lordship, no any information, neither rejection, no anything, Lordship. So I'm just praying for Lordship disposal of my petition to provide me the notified service in a time-bound manner, Lordship. Since my second appeal is also pending, Lordship.
When did you file your, this is a public service, notified public service?
Yes, Lordship.
This is, your prayer is for mutation or what?
Mutation and partition of 10 lessons of land, Lordship.
Partition, we don't know.
Mutation, Lordship.
Yes, Miss. Mr. Borua, before the original authority,
Lordship.
First appellate authority, second appellate authority. He has preferred application. Some outcome, yes or no, should be there. Yes or no?
Yes, very well.
We don't know the ground situation, but they must act.
Or else, Lordship may, instead of taking instruction, may dispose of with a direction to.
Oh, see, these are statutory authorities.
Yes, because that.
See, these are statutory authorities.
They
It
have-
is not that they are. Now, they have been given the task under the Act to provide the notified service within
Limited period.
limited
Yes.
time of period, timeline. timeline.
Section 5, yes.
So, if they do not act, where the citizen will go? To get the instruction first.
Yes.
Because directing, monitoring something is different thing.
I will have it. It's from
Heard Mr. Eskedas.
Lordship may also issue notice. Lordship.
So let the instruction come in first.
Notice, Mr., it will delay the process.
Lordship, yes, Lordship.
If you want,
Lordship.
notice.
Lordship.
Because directing a statutory authority is one thing.
Lordship.
Eskedas. Mr. S. Borua, Junior Government Advocate Assam for the respond number 1, 3, 4, and 5. MSG, sorry, and Board Learned Standing Council, Revenue and Disaster Management Department for the respond number 2. Full stop. It is the case of the petitioner that he purchased a plot of land measuring 10 lesses, covered by DAG number 1009 and KP pattern number 496, situate at Revenue Village, Coral, Moza, Ramcharani, Kamrup Metro. Why they registered till date dated 24/9/2015. According to petitioner, to get the notified public service of mutation and demarcation.
And partition.
Huh?
Mutation and partition.
Mutation and partition. As regards the subject land, the petitioner had preferred an application. Any number?
Yes, Lordship. My first application number at page 47. And page 48.
Application. Two application. Application number. Application registered as application ID page 47 and Excel 7. Or application ID number dated 22/11/2021.
And another Lordship 1/16/2023, page 48.
What is this application? First, 47 is what? 48, I could understand mutation.
Yes.
Where is the partition?
It is mutation also. It is mutation.
Mutation stroke partition liquidated. Full stop. When the notified service was not extended, notified public service was not extended as per the timeline prescribed by the Assam Right to Public Services Act 2012. The petitioner preferred first appeal before the appellate authority First appellate authority. Post of when the first appeal was not disposed of, the petitioner preferred preferred second appeal before the Assam Administrative Tribunal. Full stop. As none of the three authorities, statutory authorities, had considered, has considered and disposed of the petitioner's application seeking notified public service, the petitioner has preferred the instant writ petition. Full stop. Mr. Borua, learned junior government advocate, Assam, appearing for the respondent number so and so 1, 2, 4, and 5. Shall obtain instruction as regards the status of the petitioner's application seeking notified public service of mediation stroke partition. Mr. Borua has sought for 10 days time to obtain the necessary instructions. Lays the case on.
Item 16.
My lord, resolution number 6 is entered into the agreement with me. What about 2020?
Respondent number?
Number 6, my lord.
6.
6, my lord.
Yes.
Entered into an agreement with me to sell a plot of land measuring 1 bigger. Under that number.
Agreement for sale of land.
My lord.
You are the purchaser.
Purchaser, my lord.
Okay.
Land is land belongs to Patan
You
number.
paid advance money.
My lord, advance money I have paid 70,000. And 2,30,000 was to be given on the date of my final registration, date of registration, my lord. And
Agreement into for sale of plot of land. Then what happened?
After completion of the 8 months,
okay, he has no land.
But there actually there is no land, my lord. In Patan number 1, rather its land is in Patan number 2. We have come to know that his land is in Patan number 1, but at present she is denying that fact that she has not made any agreement with me, and she is threatening me. Then whenever I approach me for that she should execute the registration, but she denies, my lord, and she threatens me. In this regard, I have filed an FIR before the Silchar police station, but the police personnel has not registered the case. And she is I am in trouble, my lord, that she is denying the fact and threatening me. That's the my case.
Mr. Borua, paragraph 7, fourth line. See what respondent number 6 is saying to the petitioner. Still, OC is not registering the case. That is your case.
My lord.
So
So he has
why you have come here?
he 156 3.
Why you have come here?
Lord, she is denying that if she has not made any agreement with me, my lord.
What about the big book, Code of Criminal Procedure 1973?
My lord.
What about the big book
It's,
and section 156(3)?
My lord, my lord, to file for before the
What about 156(3)?
156, my lord.
Every day we are receiving this kind of petitions, Mr. Borua.
They feel they will get a prompt response from the court.
Heard, Mr.
Yes, that's my lord.
S. Das, learned counsel for the petitioner. See what the respondent number 6 is saying to the petitioner.
They will chop up.
And Mr. S. Borua, learned junior government advocate Assam for the respondent number.
All the respondents.
All the respondents. Full stop. The petitioner.
All the respondent barring 6.
1 to 5.
Yes.
Full stop. The case projected by the petitioner in the instant writ petition prepared under Article 226 of the Constitution of India is, in brief, that, this, the petitioner entered into an agreement for sale of land measuring 1 biga covered by DAG number 132, 133, patta number 1 of 2nd RS Porgona, Tatla, Moja, Notun, Kanchanpur, District Kachar, with the respondent number 6. And the sale price subject of the subject plot was fixed at rupees 3 lakh. Full stop. The petitioner has stated that an amount of rupees 70,000 was paid to the respondent number 6 as advance money in presence of attesting witnesses. Full stop. The respondent number 6 promised, assured that a sale deed would be executed with the petitioner within a period of 8 months if the petitioner pays the outstanding amount of rupees 2,30,000. When the petitioner inquired about the landholding right of the petitioner, respondent number 6, in the records of right, it came to the knowledge of the petitioner that the respondent number 6 had no landholding right in patta number 1 of 2nd RS Porgona Chatla. So rather, the name of the respondent number 6 appears in patta number 2. Also, when the petitioner approached the respondent number 6, the respondent number 6 denied execution of sale deed on the basis of the agreement for sale of land. And the petitioner had to institute a title suit, title suit number 144/2023 for specific performance before the court of land, Munship number 4, Kachar at Silsor, and the same title suit is pending as on date. Full stop. It is the further allegation of the petitioner that the petitioner further stated that the petitioner had lodged a first information report before the officer in charge, Silsor Sodor Police Station, on 22/9/2023, alleging inter alia that the respondent of 6 used to roam around . 'Roam' the house of the petitioner threatening to kill the petitioner and his children. Full stop. It is the allegation of the petitioner that despite lodging the FIR on 22/9/2023, alleging commission of cognizable offences, the officer in charge, Silsor Sodar Police Station, has not registered a case. Full stop. Did you approach Superintendent of Police?
No, my lord.
Tapera. On a query made to the Learned Counsel for the petitioner. The Learned Counsel for the petitioner submitted that the petitioner has not approached the Superintendent of Police, jurisdiction Superintendent of Police, till date with a grievance that his FIR lodged on 22/9/2023 has not yet been registered by the officer in charge, Silsor Sodar Police Station. Full stop. চাকৰি বস্তুটো নালাগে এইটো লেটেষ্ট আগৰ তাৰিখ আছে চাকৰি বস্তুটো দিল Pera. In this connection, paragraph 4. Paragraph 4. Paragraph. It would be appropriate to refer to the following observations made by the Honorable Supreme Court of India in Sakiri Bosu versus State of Uttar Pradesh and reported in so and so. Paragraph 111. In this connection, we'd like to state that if a person has a grievance that the police station is not registering his FIR under section 154 CRPC, then he can approach the Superintendent of Police under section 154 CRPC by an application in writing. So stop. 11, 13, 15, 16, 17, 24, 25, 26, 27. After next paragraph 4, 25, 6, 7. In view of the above fact situation obtaining in the case, as have been projected briefly above, and in the light of the observations of the Honorable Supreme Court of India in Sakiri Basu, Supra and Sudhir Bhaskar of Kampe, this petition seeking the above direction is not entertained, reserving the liberty. However, to the petitioner to avail the remedy of approaching the jurisdictional Superintendent of Police under section 154(3) and thereafter, the jurisdictional magistrate under section 156(3) CRPC, if so advised. So while not entertaining the petition, this court like to clarify. The instant petition is preferred, seeking a writ in the nature of mandamus to direct the respondent authorities, more particularly the respondent of 5, that is officer in charge, Silsor Sodar Police Station, Silsor Kachar, to raise a case on the basis of the FIR dated 22/9/2023 lodged by the petitioner, and to make investigation of the case and to ensure action against the respondent persons. You approach 154(3), then 156(3). Oh,
Item number 17. Comments.
Yes.
May I please, your lordship? In this case, your lordship, on 07/01/2016, your lordship, the husband of the petitioner killed by two Montes Marak and Lipson Marak. And accordingly, Pragjotishpur police case by PSK.
Yes, any Assam State Legal Service Authority counsel? Have you served?
Yes, lordship.
Okay. MS R. Chaudhary perhaps?
Yes,
he
lordship.
is there. Find
After-
out whether she is available or not.
Lordship.
Your grievance is that appeal is not considered
Yes, lordship.
expeditiously.
Yes, lordship. On 8th February, lordship, BC case already registered and petitioner also called for affair before the respondent number, office of respondent number 4. And
State Legal Service. Then why you are,
after filing this read petition here, lordship.
then why you are pursuing? Let them
Yes, lordship. but,
continue then.
2 days.
Why we should monitor? If that case has been registered,
Yes, lordship.
better
After
you wait
filing
for
this
some.
read petition, there,
Whatever.
there, lordship.
Whatever. Now the case has been registered.
Yes, lordship.
The case will be progressing.
Lordship.
Then why you are, after some time, if you have grievance that they are not progressing in a fair manner, then you come.
Lordship.
Then don't burden this court with this. Another court is, authority is taking up your matter now.
Yes, lordship.
Okay, with the, in the event of subsequent cause of action, you are
Lordship.
put.
Deeply.
Mr. S.I. Akan, learned counsel for the petition, has submitted that the Assam State Legal Service Authority has registered the application of the petitioner recently
Yeah.
and has posted the case for further hearing.
Yes.
So in view of the same, he has submitted that the petitioner is not pursuing the instant writ petition, with the liberty to approach again in the event of any subsequent cause of action. So in view of the above submission made by Mr. Akan, the late petition is dismissed as not placed, with the liberty as prayed for.
Item 18.
Yes, madam.
May I please, your lordship, this matter related to my lord, land acquisition matter, my lord. Thus, the land, the petitioner has the, my lord, the owner and proprietors of the land, my lord.
Your land have been acquired.
Yes, my, acquired, my lord. The,
Procedure not followed.
Not followed by the property.
Okay, we'll issue notice at this stage. Heart MS D. Shunwal, learned counsel for the petitioner. MS R. Deka, learned counsel appearing for Mr. R.M. Rao,
Yes.
Planning Council Water Issues Department for the respondent number 1.
1 and 4, your lord.
4. Mr. Revenue, N. Bordo, Standing Council Revenue and Disaster Management Department for the respondent number 2. Mr. S. Borwal, Junior Government Advocate Assam for the respondent number 3.
3 and 6.
6. And who is irrigation? MS? BS Quor. DS New. Standing Council Irrigation Department for the respondent number 5. And Mr. H. Borwal, and Council representing Mr. B. Google and Standing Council Finance Department for the respondent number 7. Full stop. How many petitioner? The common grievance of the petitioner is that the respondent authorities have acquired their patalans.
Yes, my lord.
Patalans.
Patalans Meadi land, my lord.
Okay. Periodic patalans. For the construction of what?
Kumotia Lake Bank Embankment, my lord. At Hemasi.
Kumotia Dike Left Bank Embankment at block number Gurathali and Gurathali number 2. District Dhemaji. Full stop. But the respondent authorities have not followed the procedure prescribed under the right to fair information and transparency in land acquisition, Rehabilitation and Resettlement Act 2013, more particularly, the provisions contained in section 21 and section 23 thereof. First of issue notice returnable on so-and-so. As so-and-so had accepted no formal notice, extra copies of the repetition within 2 working days. এইটো দি দিব এইটো কিবা আছিল না এইটো কিবা এটা আছিল না এটা কিবা টাইমিং
Lordship, I pray for
Timing.
reflecting the name of the SC revenue in the cost.
Okay, the name of standing council. No, there is one matter, Mr.
One.
Item number 9.53.
It to 9 again.
Wait, please, your lordship.
Mr. Kakuti, you are in
Lord,
item number
item 53, lordship.
53. ये अपनी आगे समय लिखी
May I start, lordship?
Yes.
The petitioners here are all elected presidents of Gaon Panchayats, especially Gaon Panchayats. The Gaon Panchayat term has just expired, lordship, recently. Now, lordship, that law is very clear. Rule section 6 says that section 7 says that tenure is for 5 years. Section 8 mandates that the election to constitute Gaon Panchayat shall be completed before expiration of the duration specified in section 7. That means before expiry of this body, the election should be completed, a new body should be there already formed. So that there will be no break. A Panchayat body will hand over to another Panchayat body. There should be, that is that intention of the law. Now, lordship, here, this February, lordship, that the term has expired. But February 24, lordship. 24, lordship, the term has expired. But in the meanwhile, the State and Election Commission failed to hold the elections. They violated the mandate of section 8(1). Similar cases arisen, lordship, in 2007 about Uttar Dhavaje. Exact similar case, lordship. I have annexed the judgment, but you may kindly peruse at page 33, lordship. The lordship, I kindly see that the order passed by the government in that case was that in the very first page itself notice. This is for information, lordship got it. This was information all consulted on completion of tenure of 5 years with effect from date of this first meeting. All Gaon Panchayats and Anchalik Panchayats and Jilla Parishads shall automatically stand dissolved. Upon such dissolution, all properties of such Gaon Panchayats, Anchalik Panchayats and Jilla Parishad shall be vested in the government till constitution of new bodies. This was challenged in the deed petition, a series of cases, lordship. That was which have annexed. Ultimately, this court held, giving citation of many Supreme Court cases, that it has happened. Panchayat, you cannot do that because the failure to hold the election was because of the fault of the government, no fault of the petitioners. That means not for the Gaon Panchayats. So the last page, lordship kindly see, page 38. The direction given by this court is that para 14, lordship. Subrule, surplus, lordship, para D. The Gaon Panchayat, Anchalik Panchayat and Jilla Parishad, whose terms had expired because of the failure on the part of the state respondents and the State Election Commission to fulfill the mandates of the Constitution to hold the election before the expiry of their term shall be allowed to function till the constitution of the new Gaon Panchayats, Anchalik Panchayats and Jilla Parishads after complete the elections. But they are not allowed to take any major political policy decisions, make any expenditure from the funds other than the payment of salaries of the staffs and routine functions of the office. This is the direction given by this court, lordship. Another situation had arisen, lordship, subsequently. A huge number of applications are filed because of the updating of the NRC. The election could not be held. That was also, lordship, it was decided by this honorable court. Here,
What is the citation?
Citation Lordship, giving the citation Lordship, this is 2018 3 GLT 699.
2018 3 GLT
699 Lordship.
Okay.
Good Mongol Day, Lordship. Here, Lordship, that about 200 petitions are filed on this ground. That the state has taken a stand, Lordship, that we could not hold the election because we could not update the NRC. It has taken a lot of times. Because of that, but the Honorable Court considered that there was a justified reason for which election could not be held. And Lordship, that it has discussed earlier case also. That, but the court state, Lordship, that para 38, para 34. I just read out, Lordship. The Uttar Dhemaji Gaon Panchayat, this court, that is the earlier case, I've said it. This court permitted continuation of the earlier elected Panchayat bodies whose term had expired on the ground that the state could not take advantage of its own wrong and that the state had failed to hold the elections before expiry of the stipulated period of time. The fact situation in the present batch of cases is clearly distinguishable from that of the Uttar Dhemaji. Subsequent case, which has been dealt by the High Court in 2018, that the facts are totally different. It has not touched the earlier cases. This is justified because of failure of the state government. The election could not be held. Therefore, they cannot take the advantage of it. Now, this is the legal position of the High Court position, Lordship. So, Dhemaji case still exists, Lordship. That ruling still exists. Now, present case, Lordship, will kindly turn to page, the impugned order, Annexure 4, page 31. This is the order being challenged now, Lordship. Dated 3rd February 2024. Governor of Assam is pleased to allow the concerned district commissioner or his authorized officers to officiate as the custodian of property of the Gaon Panchayat, Anchalik Panchayat and Jilla Parishad for a gap period, that is after completion of the term until completion of the election process. As election cannot be held within the permissible time. For why election could not be held, that is not explained here. There's no reason for not holding the election also because NRC position, these are all clear. Now there is no disturbances. Now next line, Lordship, will kindly see of this order. This issued in pursuant of section 7, 35, 68 and section 125 4 B of the Assam Panchayat elections. The government has invoked section 125 4B to pass this order, Lordship. But 25B, Lordship, want to read totally in different situations. That is applicable, Lordship. I'll read the sections. Section 125, Lordship. Here, the panchayats are dissolved when because of the corruption or incompetence or anything. In that situation, only this is applicable.
In opinion of the
In the opinion of the government, the Gaon Panchayat, Anchal Panchayat, Jilla Parishad exceeds or abuses its powers or is not competent to perform or make persistent default in the performance of the duties imposed on it under this Act or any other law for the time being enforced. The government may, by an order published in the official gazette, dissolve such Gaon Panchayats. These are what a fault of the Gaon Panchayats if they are dissolved or they are indulging all this corruption and whatnot. Then subsequent order can be passed. Lordship kindly said subsection 4. Section 4 says, if a Gaon Panchayat or an Anchalik Panchayat or Jilla Parishad is dissolved, that means earlier, all the powers and duties of the Gaon Panchayat or Anchalik Panchayat or Jilla Parishad shall during the period of its dissolution be exercised or performed by such person or persons as the government may from time to time appoint in this behalf. Now, B, Lordship, this is important. All property in such situation, Lordship, all property vested in the Gaon Panchayat or Anchalik Panchayat or Jilla Parishad shall during the period of dissolution vest in the government. This is the only power given, this is the only section dealing with giving power to the government to take over the properties of the panchayats. But that is also not applicable in the present case. This can be done only when the panchayat is dissolved because of its inefficiency, because of misconduct. Present case is not that, Lordship. Present case is that it is expired, but government failed to hold the elections. So this is their, Lordship, which they have invoked. On the basis of this 125, this is they are invoking this power to pass this order. It's entirely wrong. This is not applicable, Lordship. There is no other power, no other section gives power to the government to take up the properties of the panchayats to take us to this. So, Dhemaji Uttar Dhemaji, that is 2007 decision, which is still in force, that has to be followed now. We hold the elections. Until then, allow us to continue in the office. We shall not take any major decision regarding financial action. And this is the mandate of Congress Constitution of 243E, duration of panchayat action. Sufficient order is out and out illegal order. Government has invoked a wrong session and passed this order. It's good. Therefore, no. So, by invoking a wrong section, government has passed this order. It cannot be sustained for a single day, Lordship. It's an out and out illegal order. That's my submission, Lordship. Order may be.
Whether in that judgment,
Lordship,
because from perusal, that's the cursory perusal that affidavits were filed there.
The Advocate General appeared in that case. Dhemaji case.
Affidavits were filed by the government.
Government filed the affidavit and they tried to justify.
And State Election Commission.
Lordship.
You not made the State Election Commission a party here.
Yes. But they also appear as their.
No, in your petition.
Election.
They are not party.
Not made a party because yes. We can make Lordship made.
Because I think they are entrusted with the duty.
Is that unread? State has to.
In the second petition also, Mr. Mohanta. Because they have the duty to hold the election.
It has to be entrusted, otherwise not. Government has to entrust it. And in that case, final also, which is the 2018 minor, the 399. That case,
You are what are the prayers?
They are till you and bodies come, my lord. I will do this, and then what will be allowed to continue.
With the financial restrictions, Lordship, as stated in Dhemaji's case, Lordship.
That part then, to hold the panchayat election, that part will not be, in absence of election commission, that part may not be enforced.
has been started by the government. Regarding.
No.
So this is the duty, my lord, that does before it, it has been started done before 6 months of the, my lord, expiry of the term.
Commission also.
Here, my lord, all the settlement of the motor was passed by one of the motor, I have an next one. It's 35.
Children allowed to continue, but not financial.
Yes, anything?
My lord, that, in fact, my lord, that order was based on, has your lordship got, my lord, that, that was based on, my lord, 1374/2018. And that in that also there is an interim order, my lord. That in a similar line, my lord. This is the order.
Yes. How much time it will take? Hardly 3 minutes or 4 minutes. Okay. This is beyond 1, that is why.
Yes. If lordship will please take up at 2 o'clock, no.
Okay, 2 o'clock. better.
Subject to they offer me a cup of tea, lord.
Item 953.
Agal, opening person. Good. Please receive the phone.
My lord, that judgment, your lordship, signed in 2018, my lord, and that was, my lord, although interim order was passed ultimately, my lord, because already election was declared, and they are late because of the reason that, my lord, there is a NRC work is going on. That's why that was the reason they have not able to find able to declare hold the election, my lord. But here, my lord, is the normal situation. Your lordship kindly see that as per the constitution, it has to be done, my lord, prior to 6 months of the expiry of the term. But they have not even. The preliminary work has not been done regarding election. Your lordship kindly see the impugn order. Your lordship kindly see they have stated that page, my lord, 23 of my petition, my lord. Page 23, my lord. The impugn order. The government of Assam is pleased to follow, allowed to consider district commissioner of his authorized officer to officiate as the custodian of the property of the Gaon Panchayat, Anchalik Panchayat, Jila Parishad of the for gap period, that is for after completion of the terms till completion of the election process, as election could not be held within permissible time limit. So they admit that they are unable to hold the election in the permissible time limit. This issue was pursuant to the section 7. Section 7 is applicable to us because we are the Gaon Panchayat. 35 and 68 is not applicable to us. And 125(4), that is, my lord, already my learned senior fan has read it out. That is not applicable to me. Applying this, my lord, all property has been now, my lord, entrusted with the video. In respect of, my lord, Gaon Panchayat, it is video. Now, my lord, they are probably they will come with the argument that yes,
The coming election is coming, my lord, or Lok Sabha election is coming, my lord. Sir, current event cannot be stopped, my lord. So my submission before is like, my lord, other order passed by this honorable court in earlier occasion, my lord. So similar order may be passed, my lord. That's my submission, my lord.
Lordship may kindly take the Constitution of India. Article 243E, the language, the wordings there. Panchayats, part 9, 243E. May I read it, Lordship? Duration of the panchayats, etc. Every panchayat, unless sooner dissolved under any law for a time being in force, shall continue for 5 years from the date appointed for its first meeting and no longer. No amendment of the law for the time being in force shall have the effect of causing dissolution. We are not concerned about anything else. 243E1. Very specific, the scheme of the constitution is very clear that the duration of the panchayat, etc., cannot go beyond 5 years after the first meeting and no longer. This word is very specific. And that is the interpretation of series of cases all across the country, including the Honorable Supreme Court, while interpreting 243E. I have gone through it. In my hearing, I'll place all the judgments. 2-3 judgments I'll try to make out. Whatever may be the consequence, whatever may be the reason, whatever may be the compulsions, the election could not be held within the previous 6 months of the completion of the tenure. Nowhere, under no situation, the tenure of the existing panchayat or existing Gaon Panchayat, Anchalik Panchayat or the body can go beyond 5 years. So, the locus of the petitioners, in my humble submission, is governed by this, that after the completion of the 5 years tenure, they have no legs to stand any further. Whatever may be the options thereafter, Lordship, that will have to be exercised by the honorable courts or by the government. But they do not have any enforceable right to continue. There can be some stopgap arrangement. The stopgap arrangement has been considered by this honorable court also. Now, without making election commission a party, because if Lordship is pleased to look at their prayers, in fact, Lordship has already highlighted that, they have prayer, that first prayer at page 20 of the case of Joinab Bibi, they want a mandamus. So all subsequent and notification and a mandamus should not be issued directing the respondent authorities to allow the petitioners to discharge and function of the panchayat till the new Gaon Panchayat is elected. That means they want extension of the tenure beyond 5 years, which is purely unconstitutional prayer. They have to first challenge 243E. Then only this prayer will be considered by this honorable court. This honorable court or any other court of law, Lordship, will not do something which is not permitted by the Constitution. When the 73rd Amendment was brought, all these things were deliberated. Years after years, extension was granted, etc. To cut that menace, Lordship, this no longer word has been inserted. And they are also praying for the order of 3/2/2024 for sitting aside. That means the deputy commissioner, the district commissioners or his authorized officers to officiate as the custodian of the property of Gaon Panchayat. So basically, nobody is going to run the panchayat during this period. It will be only the part of custodian. They themselves are trustee. They are not the owners. Whoever has come before this honorable court in the form of writ petitioners, they are not owners. They were custodian, they were trustees on the basis of their election, and that specific period was for 5 years, they will be the custodian, not beyond that. So after that, it is not their business anymore. So this order they have challenged. Now, one submission has been made that government for a future event is not holding election. What is that future event? That is the ensuing general election of the country, including in Assam. But they have missed out a very important event that has taken place after 23 years. That is the delimitation exercise. Lordship knows during the course of last 6 months, the delimitation exercise was completed. There were several districts which were either they were created or they were merged. All these things happened during the course of last 6 months. So these are factual aspects. When they say that for future event, that is a factual thing they are uttering before this honorable court. My response would be, Lordship, that we will have to give a proper response on the factual aspect. On the legal aspect, Lordship, I'll place all the judgments and I'll try to distinguish also. As because in 2019-20, the honorable court did not interfere with the same order. If Lordship is pleased to take up that judgment.
Any appeal was preferred against this order?
Which one, Lordship?
That they have
2003, that.
No, that which they have annexed at page 33.
That I'll go through the judgment. How it was dealt with by another division, another single bench of this honorable court in Arunachal Pradesh. I'll place that order. The jailer. That is a bad law, Lordship, and that was submitted before the honorable court by the then Advocate General of Arunachal. 2019, 7 GLR, page 612. Sangha Tagik versus State of Arunachal.
2019?
2019, 7 GLR, page 612.
That is in respect of?
Sangha Tagik versus Arunachal. Here also the election was not conducted.
Of what body?
Of the body of Panchayat only, Lordship. Yes, Panchayat. Have Lordship got the book? Lordship may take the book. I think I'll be able to take it from my. Lordship will kindly come to paragraph 11. I'd like to read from paragraph 10 onwards. They have referred to the other side, referred to Uttar Hemaji also, the previous is page 19, paragraph 9. May I read it from 9 onwards also? The advancing strenuous argument, Mr. T.T. Tara, learned counsel for the petitioner, submitted that the state respondent had violated the mandate of Article 243A of the Constitution of India by not convening a concurrent comment on the proposed schedule of holding the general election to the Panchayat to the State Election Commission. According to Mr. Tara, the government is duty bound to comply with the mandate of the Constitution of India provided under Article 243E, wherein the election to constitute a Panchayat shall be completed before the expiry of the duration of 5 years. Mr. Tara also submitted that Section 104(1) of the chapter so-and-so of Arunachal Pradesh Panchayati Raj Act 1997 provides that the superintendent's direction and control of the preparation of the electoral roll for the purpose of holding election to the Panchayat bodies are vested in the SEC, that is State Election Commission, and it is the duty of the state government under Section 104, subsection 3 of the said Act to provide to the SEC required staff, but the state government has not discharged its duties and obligations under the Act. The aforesaid grounds cited by the state government for its inability to hold election as per the mandate of the Constitution the Tara Learned Counsel for the petition submitted are not sustainable in law in view of the Catanab judgment rendered by the Honorable Supreme Court and this court holding the effect that the state cannot dilute mandatory requirement of compliance of the mandate of Constitution of India provided under Article 243E by making an endeavor to amend the provisions of Section 10(3) of the Section 18 of the Arunachal Act by means of administrative decision. They did not want to hold election actually. Mr. Tara further submitted that the state government being committed to the welfare of the people of Arunachal must act fairly and reasonably, and as such withholding of election to the Panchayat body is clearly violative of Article 14, 19, 21, 243B, 243E of the Constitution of India. Tara contended that Article so-and-so shows that the framer of the Constitution had envisaged village Panchayat to be the foundation of the country's political democracy, etc. This is the basic thing from their side. He cited Poob Mongoldoy Ancholik Panchayat case that 2018, Uttar Dhemaji Gaon Panchayat, Jotindra Kumar Thausen 2007 case, and then 3 other cases. Par contra, Mr. N. Dr. Learned Advocate General Arunachal submitted that the Constitution 73rd Amendment 1992 heralded a new era in the federal democratic setup of the country by providing constitutional status to the PRIs to ensure self-governance to the village populace. Mr. Dr. contended that one of the directive principles of the state as enshrined in Article 40 of the Constitution of India is that the state shall take steps to constitute village panchayats and appropriately empower them to with authority to, as deemed necessary to enable them to function as units of self-government. After the Supreme Court made some reservations in the judgment of Parakasam District Sarpanch Association versus AP government, Datta submitted that the government of Arunachal Pradesh amended the Arunachal Pradesh Panchayati Raj Act 1997 by the Arunachal Pradesh Panchayati Raj Amendment Act 2018, replacing the 3-tier Panchayati Raj system by 2 tiers in view of the provisions provided in Article 243B(1)(2) of the Constitution of India, which was notified in the Arunachal Pradesh Gazette in its extraordinary so-and-so. Skipping all this part, Lordship, where there is a reference to, yes, Lordship will kindly come to paragraph 17. One more submission. In the same paragraph, paragraph 10, one of the Datta's submission was, Mr. Datta contended that as per its mandate, the government of Arunachal is duty bound to rearrange the territorial constituency of each panchayat area, taking into consideration of the population of each such constituency and the number of seats allotted to it and to the state legislature to make suitable provisions by law in matters of election to the panchayat as required under Article 243K. And further validity of law relating to delimitation of the panchayat constituencies or the allotment of seats to such constituencies made under Article 243K cannot be called in question in any court of law under Article 243 of the Constitution, though subject to judicial review based on test of distinctive basic features of the Constitution. Doctor, referring to the content of the letter dated so-and-so, he referred to this judgment, Lordship. I have gone through it. Yes, paragraph 12. Paragraph 12. Mr. Dr. Learned Advocate General further submitted that the judgment passed by this court in Uttar Dhemaji Gaon Panchayat case was being in conflict with the mandate of Article 243E of the Constitution of India. It was said corrected later on by this court in the judgment passed in Uttar Poob Mongoldoy Ancholik Panchayat
What is that,
case.
Poob Mongoldoy?
That Poob Mongoldoy, Malay Justice A.K. Goswami's judgment.
That is interim order.
Go to, after this, I will go there.
Mongol, that is 2018 3GL.
There,
69.
an interim order was passed, which they are relying on that. In that situation, then when the affidavits came for the Election Commission, as well as from the state of Assam, that large number of officials were deployed for the NRC updation exercise, Lordship. The Honorable Court said that this is a valid ground and the delay cannot be attributed to the state of Assam or the State Election Commission. And therefore, the same order, when the deputy commissioners were entrusted to take charge of the panchayati institutions, Lordship, that was upheld. So now, once our affidavit comes, then only this Honorable Court would be able to assess whether there is any fault lies with the state of Assam or there is no fault. Now, one very vital thing is that State Election Commission is the most important party in this case. In all the judgments, I gone through about 50 cases during this time, during the lunch break. Everywhere it is the main defense has been forwarded by the State Election Commission. Whether it is in Chennai, it is in Madhya Pradesh, it is in Maharashtra.
The
it is
state
in-
can file the affidavit.
We can file the affidavit, but that is one side of the story. Normally, the role is very autonomous that the State Election Commission has to do. In some cases, state do not provide the manpower. In some cases, state do not provide the fund to conduct election deliberately. Now, what is the situation here? Why Election Commission has failed to conduct election? This is autonomous body. State cannot dictate. The duty cast upon the State Election Commission to hold the election at least 6 months prior to the date of completion of the tenure. And if they are finding some problem, because in the recent delimitation exercise, normally the delimitation commission conducts the delimitation exercise. Is for Assam and JNK Lordship, this is a special situation when the Honorable Supreme Court directed that the State National Election Commission will conduct the delimitation exercise. And state is a part of that exercise. So all these facts will come up. Now, after this, what this Honorable Court said.
What is the ratio in Kishan Singh Tomar?
Kishan Singh Tomar's, that is regarding Panchayat.
But that provision 243 EU is perimeter to 243.
243 here also ultimately, as because the election was already conducted. But one thing in several lines, there is a clear finding that nobody can go beyond the period of 5 years. Whether it is a panchayat, it is a municipality or a corporation.
Kishan Singh Tomar
Yes.
also says 243 clause 3
Yes.
or 243 EU clause 3. This is a failure on the part of the
State. As because the election was already declared there, so nothing was done, basically. Some observations we can rely upon from this Kishan Singh Tomar's case. Paragraph 27 says, Article 243K also recognizes the independent status of the State Election Commission. So when I am saying that it's an autonomous body, state has no control over it. Whether it is the Election Commission of India, the central government has no control. Identically, Lordship, in the State Election Commission cannot depend upon any direction or cannot take any direction from the state government. It is an autonomous body. They have to apply their own mind, own application of decision-making process. Only when the state sabotages or a malafide intention, then Lordship, the blame can be taken by the state government. Now, in the instant case, till now, I have no concrete factual information from the state side why the election was delayed. Recently, only one statement I have gone through in the media that state government chief minister made a public statement that election will be held immediately after the general election.
Because whether completion of say electoral roll, preparation and completion of electoral rolls.
That has been completed now.
Or any other situation, whether those will be valid down to not to follow the provision of clause 3 of 243E. That is one part.
That is one part.
Second part is continuation of this to allow
Continuation of the tenure.
That is the interim one.
That is the interim one.
Interim one till the decision on the writ petition.
Yes.
Right. There are two parts to it. One part, it is expressly evident that clause 3 is not complied with.
It is not complied.
Adjuncting.
Yes, but for that, whether the petitioner will get some benefit.
Only that is the issue.
That is the issue. So whether, now, one thing is very clear. Whatever, suppose the government is at fault, 100% it's a state government's fault also. Let us assume that. Whether that will allow them to go beyond Article 243 U, E.
E or U, whatever.
Yes.
or sub-
That beyond and no longer, that no longer has lot of importance.
Yes.
No longer, not a single day, not a single moment they can continue in that office.
Whether that provision has been considered in this judgment.
It has been stated, no explanation, no reasoning. Just
This quote unquote, the phrase no longer has been considered in this judgment.
I have gone through it, no, Lordship.
I had not the occasion to go through it.
I have
I'm
gone,
asking Mr.
because I was about to make that argument that 243 says no longer it can continue beyond the 5 years tenure. No longer argument was never considered. Neither 243 E has been considered.
Is there any other judgment?
Yes,
because I was a part of it, division bench.
That these
Honorable Justice N. Koteshwar Singh delivered a judgment as regards this issue no longer.
I'll find it out because I
I forgot what is there, but it was about
I prepared the case when they were arguing.
60 pages. It was about 60, 70 pages. Now I have forgotten everything.
Yes, we will find it out, Lordship.
But when he was acting Chief Justice,
Lordship. So
I think that issue has been dealt with, that no longer.
Yes.
Every judgment about.
Yes. No longer, I'll find, definitely there will be some. Now, this is the first prayer I have read out. What are the next prayer? To hold election.
Not that PRI, CSO, that is not relevant here as of date.
Lordship.
That page 30. Second prayer.
Second prayer is not, and third prayer, and direct the respondent authorities to hold election. Now, who is the respondent authority? They are not party here. So they want the state election commission to conduct election without making them a party.
Koteshwar Singh or more. Koteshwar Singh or more. Now that activate the platform of PRI, CSO, that is not the issue here. Main issue is whether to allow the elected members of the earlier PRIs to continue beyond 5 years.
Yes.
That is the interim prayer.
That is the ultimate prayer also. That is the ultimate prayer. So my another round of argument will be that on the very first day, they cannot get the final relief. I don't have to show any judgment on them. That will be the final relief. But everything will be considered, maybe considered by this honorable court. Once we find
what has been observed in Poob Mongoldoi?
Poob Mongoldoi, Lordship.
Actually, Poob Mongoldoi, my lord, by this time, when the final result, my lord, final decision has come, my lord, already election was declared, my lord, election was held. Probably they are taking your lordship, go by the last para.
Paragraph 32, Lordship will kindly come.
Paragraph 34 is 35 is the 11.
Now, paragraph 32, may I read it, Lordship? Poob Mongoldoi. From the above, because here, all these paragraphs, previous paragraphs were quotings from the affidavit of the state government as well as the State Election Commission. From the above order, it is evident that utmost priority has to be given for upgradation and preparation of NRC. The ongoing work of NRC upgradation is not a regular phenomenon. Order dated 27/3/2018 of the Honorable Supreme Court had also clearly mandated that the manpower of the state government currently engaged in the work of upgradation of NRC will not be replaced or substituted save and except services of one additional deputy commissioner in each district who may be currently engaged in NRC work. Affidavit of the State Election Commission reflects that sufficient spare manpower is not available for the purpose of deployment in work relating to Panchayat election. The stand of the state that a sizable section of the government officials and staffs are engaged in ongoing upgradation work of NRC is not disputed by the petitioner.
Then, Mr. Soikia, when can you file your affidavit?
Yes,
Because
Lordship. Kindly give me 2 weeks time, Lordship. We'll file it.
File maybe within a week. We can consider because here it in paragraph 34. Paragraph 34
Yes.
in Poob Mongoldoi, because NRC is a special situation.
So is delimitation.
Okay, that has to
That
come
is
on
kept-
record.
Yes.
That has to come on record.
Yes, Lordship, will come on.
Otherwise,
That is why that without
otherwise,
affidavit.
at paragraph 34,
Yes.
the court says that fact situation in the present batch of cases is clearly distinguishable from the fact of Uttar Dhemaji Gaon
Yes,
Panchayat,
Lord.
and having regard to the proviso contained in so and so, I am the considered opinion that it will not be permissible to allow the panchayat bodies whose term had already expired to continue to function and discharge the powers and duties as envisaged under the Panchayat Act.
That is another finding.
No, that is why he has distinguished the judgment annexed here. I don't know the name of the judgment. What is the name of the judgment? By
Dhemaji.
Hmm?
That is Poob Dhemaji, my lord.
Poob Dhemaji. Okay, this is Poob Dhemaji. Because names are not shown
Lordship.
in annex. Poob Dhemaji.
That is discussed here, my lord.
Page 33.
Yes.
Because he discussed
That is Uttar Dhemaji.
Uttar
and
Dhemaji, sorry, Uttar
distinguished
Dhemaji.
and distinguished in Poob Mongoldoi,
Poob Mongoldoi.
Ancholi.
Correct, my lord.
And thereafter, the court was of the view that NRC was a special situation
My lord. Correct,
and distinguished Poob Dhemaji,
my lord.
and then says it will not be permissible to allow the panchayat bodies. Page 34, sorry, para 30.
Para 34, your lordship kindly.
Though the same court had
My lord.
granted interim prayer.
Yes. Now, why granted interim pair? In fact, in this case, there is an interim pair. In this case, this judgment, my lord.
Which judgment?
That's the judgment referred. Your lordship kindly see this, my lord, Poob Mongoldoi. In that, I already have given a
Right,
copy. In that case, my lord, the interim order. Here, my lord, your
No, it is permissible to recall the
no, my lord. What?
interim
Why?
order.
In the similar line, just last earlier occasion, this honorable court passed this interim order that till the new election, new body come, then my lord, they will discharge their duty, but not to take any financial decision, not to take any major decision. So your lordship kindly see normally, so your lordship kindly one thing aside, Panchayat is a local self-government, my lord.
Right, Mr. Monto.
One elected body handed over to the another elected body, my lord.
Now,
Not
we want to see at the earliest whether the present situation is like
peasant,
Poob Dhemaji,
or
Poob Dhemaji,
or that
or
Poob Mongoldoi. Uttar Dhemaji and Poob Mongoldoi.
Poob Dhemaji or Poob Mongoldoi.
Kindly once, my lord, page para 36 kindly.
Nothing
kindly
is
see.
available before the court.
No, para 36 kindly see, my lord. Of this judgment, my lord.
Which judgment? Which judgment?
This Poob Mongoldoi.
Yes, Poob Mongoldoi.
At this stage, both Mr. Mozumdar and Mr. Bora have submitted that the further 15 days time may be granted to that newly elected body can take over such. In the meantime, election was probably over. So that's why, my lord, your lordship kindly see that situation is not the same, my lord, as with us. Here, my lord, they have not even, my lord, preliminary work has not been done. They have not.
Okay, they can file preliminary within 7 days.
And then another
Because
one, yes.
election is not going to hell within two months.
But we are already out, my lord.
7 days.
I think it will be
Preliminary.
10 days time, Lord.
Because to consider interim period, to allow you to function, for that also we have to have a
No, why I'm submitting, they have already taken all the properties by pursuing a power conferred from 125(4), which is not applicable to us.
no, this is
That
not,
by a wrong power derived from a wrong.
not personal property.
Private property, it is
My
not.
lord, I am not that, my lord. Your lordship kindly sit down. Now, who is the custodian, my lord? Who is the BDO is the custodian of the Gaon Panchayat? Where from he got that power, my lord? Your lordship kindly see the Panchayat is a local self-government.
I will say 125(4), I have not found any applicability.
Yes, my lord. So by they say that
Privacy-
their power derived from that.
Privacy 154(5), we are only on the phrase no longer.
My lord, that's true.
But
That
whether
no longer.
whether
But
any discussion was made in the Poob Dhemaji about that?
No, absolutely silent. Not
Because it
even
is a
discussed.
final judgment. It
My
is a
lord,
final
it's a
judgment.
final judgment. It's a final judgment. Khub Dhemaji and
Because
Even
that
243E.
that particular phrase, because I am also of the view that because I was a part of a division bench where that no longer
My
phrase
lord,
was
I'll try to
discussed.
find it out, my lord.
And if something order is to be passed, if that is
My lord, contrary.
contrary to my
All right, I'll try to.
part of the division bench, that will be difficult.
The language is without any vagueness here.
But there is failure also.
Failure cannot be penalized in all situations.
That is to be signaled.
That is to be. Just like in BTC area, the election was supposed to be held during the COVID time. It did not help. The governor took.
Because so
forward.
far I remember, Kishan Singh Tomar, 243E, that has been discussed subsequently also, and that has been approved.
Yes.
And few of the grounds taken by the state, it is said that that cannot be a ground for postponing.
Now it is a
The only question is allowing them to function.
Allow them to
And
function, whether
because
it will be amounting
in
to
the division bench-
extension of the tenure.
In that division bench, there was mandamus for holding election.
But my first submission would be Lordship will kindly, no doubt we'll file the affidavit, maintainability in the present form, without the state election commission.
That I'm going to, my
No,
lord.
that Lordship will not allow now. Now, after my objection, after when I'm raising the maintainability issue, that cannot be corrected. If it was the first prayer, then definitely.
Reported. Huh? Kishan, JLT আছে নাই? JLT আছে. N Koteshwar Singh. আৰু Kishan Singh Tomar মাৰি দিয়কচোন. Kishan Singh Tomar spelling to জানে? You are part of it. No.
I think at one point I was part of it. It was challenged to section 26, subsection 5 of the Municipal Act, most probably. I'll find it out. State Assam Municipal Act. Because we inserted that clause again for extension, which is not permissible. 26(5).
When can you file? Next Friday?
Today is Lordship. Just one second. Today is.
We'll consider the interim
Yes,
prayer,
My lord.
not the final prayer.
My lord.
Yes, on first I'll file it, Lordship.
You are basically interested in interim prayer.
My lord.
Then it
No,
may
if
prolong also.
They hold the election, my lord, matter will
Then
impact us.
if it goes for
As
6
done in
months,
the Indian case.
you'll be.
Win-win. Every day is everything to gain.
Okay. Third, Mr. R.P. Kakoti, Senior Counsel.
Pardon me, I just pointed one thing. This order has been passed, but like, impede on that. This issue in person to section 125(4), that invoke 125(4) and exercise the power.
I am-
Wrong and illegal.
I am of the privacy view that 125(4) is not the provision to be invoked in such a situation. My concern is only this no longer, what does it imply? 243E,
But
clause 1, last 3 words,
no longer.
quote unquote, and no longer.
That is big.
Nothing has been discussed in this Khub Dhemaji
Dhemaji.
perhaps in the entire judgment.
Yes.
So whether this observation or this direction in paragraph 14D to allow them to function,
No.
whose term has expired.
Can you see?
I have seen,
Virtually no.
I have seen.
Only paying salaries to the employees. They cannot take any financial decision. They cannot put up any expenditures. So only the owner. gives
I have
any
seen,
legal-
I have read entire thing. I have marked also, allowed them to function. Till the constitution of a new Gaon Panchayat, Anchalik Panchayat and Jila Parishad after completion of election, but they are not allowed to take any major policy decision.
Not only financial decisions.
Kishan Singh Tomar अलग है। अच्छा अच्छा अच्छा। R.P. Kakoti, Lane Senior Counsel. for the petitioners in 55, huh? 53. And Mr. Vijay Mohanto,
WPC 844.
learned counsel for the senior counsel for the petitioners in item 9. Also heard Mr. Lee Hoikya, learned Advocate General Assam, assisted by Mr. K. Moore, learned Senior Standing Counsel, Panchayat and Rural Development Department. For all the respondents. In these two writ petitions, the petitioners who were directly elected president, Gaon Panchayat presidents, have assailed a notification bearing number 32/2024 issued by the Principal Secretary to the Government of Assam, Panchayat and Rural Development Department in exercise of powers conferred under Section 7 in respect of Gaon Panchayats, Section 35 in respect of Anchalik Panchayat and Section 68 in respect of Zilla Parishads and Section 125(4) B of the Assam Panchayat Act 1994 as amended. The petitioners are stated to be aggrieved on the ground that it is impermissible under the Constitution of India not to hold election process for Panchayati Raj institutions within the before expiry of the term of the previous Panchayat bodies under Article 243E within bracket 3 of the Constitution of India. And as such, have prayed for an interim order relief in the form of allowing them to function till holding of the next election for the PRIs. Mr. Soikya, learned Advocate General Assam, has opposed the interim prayer and has also raised an issue of maintainability of the writ petitions in the present form.
Without election commission a party.
Okay. Without making the State Election Commission a party respondent in the writ petitions. Insofar as the interim prayer is concerned, he has sought for 10 days time to file a preliminary affidavit. The learned counsel for the parties have referred to. Is it reported? Poop Dhamaji?
I think it is reported. It will reported.
Okay, Uttar Dhamaji Gaon Panchayat, perhaps. Uttar Dhamaji Gaon Panchayat and others versus State of Assam and others, reported in 2007, 3 ALT 899, and Poob Mogolloy Anchalik Panchayat and others versus State of Assam, reported in 2018, 3 ZLP 699. Any other?
The Arunachal case, Lordship, I have referred to few paragraphs. The findings I have not placed. Let it be like that today.
No, I just cite because this is for my reference.
Okay, Lord. Then the finding of the learned single judge in Arunachal case There's a clear finding there. It
Is
cannot
it
go.
a reported case?
Yes, it is a reported case. I have given the book.
ZLR. And it will kiya kibo. Etu.
The
Sangha Tajik versus State of Arunachal Pradesh and others reported in 2019, 7 GLR 612. Post up.
The finding is at 17, 18, 19. One finding is very categorical that it cannot go beyond 5 years. In no case.
Release the case. I think by 1st of March, you can file the affidavit.
Yes, so I'll do that.
Then 4th of March.
Yes.
Okay, release the cases on 4/3/2024 for consideration the interim period. Full stop. The state respondents
Finding.
shall file the preliminary affidavit on or before 1/3/2000.
File your case.
এটা রাখি তো। বুক এটা এখন দিয়ে দিব। আৰু এই কিষণ এনকোটেশন চাব। কিবা এটা কোৱা আছে। No longer to put the class.
Item number 52.
But I've got the instruction, my lord, he is not the designated owner. Otherwise, at least 2 items will go with it.
Okay. Shall we record detail or giving the finding or?
That part, my lord, otherwise, the commissioner has said that yes, it's not beyond the authority.
Okay. There are many cases then tomorrow.
Then
We'll pass the order.
My lord.
Recording the finding.
Yes, my lord. Lordship may
So
indicate
far
the
as-
provision also, my lord.
Otherwise it will be difficult.
Lordship.
Mr. Counsel. Okay. As agreed to by the land council for the parties, list the cases, list the case tomorrow. As agreed to by Mr. A.R. Bhuyan, land council for the petitioner, and Mr. B. Goyal, land standing council health department. List the case tomorrow, and similarly 54 and 55. We'll decide about 55 later.
Lord.
Much problem. Item number 56.
Yes, Mr. Islam.
After some time, it is very nothing.
Hmm?
After some time, it is I'm doing it. This matter is to compensation, your lordship. This
Compensation.
that's eviction notice, your lordships.
How can we prove?
Your lordship set aside this order, and illegally they will demolish their houses. your
Others,
lordship.
matters of evidence otherwise. Okay. Next.
Item number 57.
Instruction was sought, man. Yesterday, instruction was sought from the.
Yes, yes.
What's the receiver?
To him the instruction.
Lordship. Lordship.
To him the instruction. Is there any purpose now?
No, nothing.
No purpose. Mr. Ahmed, issue is resolved. We'll note down this
My,
in the record that
Yes,
there
yes.
is a mistake that day.
my lord.
Okay. I heard Mr. H.R. Chaudhary, learned counsel for the petition, and Mr. N. Goswami, learned junior government advocate Assam for the respondent number 2, 3, and 4. Who is for 1?
For 1 year.
MS, also heard MS N. Bordoloi, learned standing counsel Revenue Department for the respondent number 1. Full stop. Agor Kali order to second pair of the video. Mr. Goswami, learned junior government advocate Assam, who was asked to obtain instructions yesterday as to whether Kali date to video bracket 20/02/2024 as to whether any eviction stroke demolition exercise was being contemplated by the jurisdictional circle officer in assistance with the police personnel from the jurisdictional police station. Post up. Para. Mr. Goswami, junior government advocate Assam, has submitted that he has received instruction from the officer in charge, Potasil Ambari Police Station, Guwahati. So he has placed a copy dated 20/2/2024. Full stop. As per full stop. The contents of the communication received from the officer in charge, Potasil Ambari Police Station, read as under. Click it A to A. As it is informed by the officer in charge, Potasil Ambari Police Station, that the police person had gone to the petitioner's plot of land on the instruction of the circle officer. Circle officer or what? In order to execute the judgment and decree passed in title execution number 14/2022, by mistake. Meaning thereby the visit to the petitioner's plot of subject plot to the subject plot was by mistake, there appears to be no further cause of action to proceed with the writ petition. Closed up. Accordingly, the writ petition is closed. So your issue is resolved within 24 hours.
Obliged.
Number 58.
May it please your lordship. What had happened in this case, on 21/12/23, the petitioner was given the benefit advantage of my lord, pre-arrest bail in cyber PS case.
Crime branch.
Crime branch, sorry, crime branch. Then my lord, I recorded my statement. Then on second time, when I went to record my submission, my lord, on 1/12/24, I was arrested. 1/2.
1/2.
I was arrested in connection with this full PS case number 42/24. My lord, in that case, I was given police custody for 12 long days, my lord. On 13th day, my lord, I was given to judicial custody. Thereafter, my lord, I was shown arrested in Gorsuk PS case number. Now, my lord, what they are doing, if I get a bail in one case, in fact, my lord, in the dispute PS case,
You put
regular,
another petition
Yeah.
for another person.
my lord,
You moved another repetition for another
yes,
person where
yes.
you
Rana Chaudhary.
want the
Number
details
of
of
cases, yes.
number of cases where you were
Because
shown as an accused or suspected to be accused.
In terms of the guidelines laid down in Uday Chand's case.
What is the repetition number and what is the order? You want same thing.
Same.
Same.
Ah.
Because
Oh.
subsequent order was passed where I have given the
Yes, yes.
details.
Yes. And in fact, they have given the details in that.
I have
Well, that number I'll give within 5 minutes, my lord.
so that
Just now I'll give. That I'll getting, my lord.
so that I can pass the similar order.
Yes.
Provide the details
Ah.
of all
You
the
pass that
cases where this petitioner is shown as an accused or suspected to be. accused.
Yes.
I
Because
think-
the idea is, my lord, when I was given ad interim bail, they could have said that he is involved in so many other cases. Then court will take note of. The court has given the advantage of bail. Now you cannot do all this mischief. I'm furnishing the number, my. Initially, Lordship passed an order that prosecution should disclose all the details.
That is one. Then thereafter they disclose the details, which I have reflected in the order.
Yes.
About 9-10 cases.
Yes, 8 cases. Yes.
I remember that.
I'm getting the order, my lord. Another order to go. WBC number 219 of 2024.
Last duta order already was. Hard
Most-
Mr. Ken Chaudhary, Lion
Mostly
Senior Counsel.
Saikya Chaudhary versus State of Assam.
Ken Chaudhary, Lion Senior Counsel for assisted by Mr. T. Deori, Lion Senior Counsel, Lion Counsel for the petitioner, and Mr. N. Goswami, Learned Junior Government Advocate Assam for all the respondents. Full stop. The petitioner has approached this petitioner is the wife of
yes.
one Sri Loikajyoti Das. Post of the petitioner has approached this court by the instant petition, stating inter alia that the petitioner's husband was initially arrested in connection with Crime Branch Police Station case number A/2023. And when a
I was not arrested. I was given anticipatory.
sorry, sorry.
I was arrested in with connection
Is
dispute.
is shown as an accused
Ah.
in Crime Branch Police Station case number A/2023 and apprehending arrest in connection with the said case, and a previous bail application was preferred,
Ah.
wherein by an order dated 22/12/2023, the petitioner's husband was extended the benefit of
Ad interim bail, my lord.
by an interim order dated 22/12/2023, the benefit of previous interim previous bail was extended to the petitioner's husband. So stop. With a further direction to appear before the IO of the case
Yes, my lord.
within a time period. Full stop. When for compliance of the direction to appear before the IO, the petitioner had gone to the Crime Branch Police Station, he was arrested on 1/2/2024 in connection with this another police case, Dispur Police Station case number 42/2024. Full stop. When the petitioner's husband was in custody,
Yes.
he was again shown arrested on 12/2/2024 in connection with Police Station, case number 375/2023. Is he behind the bar still?
Yes, now he's behind the bar, my lord.
Okay. The petitioner's husband is still in custody. Full stop. The case of the petition, the further case of the petitioner is that the petitioner's husband has been, apart from, it is the apprehension of the petitioner that the petitioner's husband, apart from being implicated in the aforementioned 3 cases, comma, is likely to be implicated in number of other cases. Full stop. It is the grievance of the petitioner that the petitioner's husband, if the petitioner's husband is allowed the benefit of bail, comma, no, apprehension that during the custody, while undergoing custody, comma, the petitioner's husband is likely to be shown arrested in other cases, and if the benefit of bail is granted, comma, he might be arrested immediately thereafter in
some other
other cases. Under such circumstances, the instant petition has been filed seeking information as to how many cases have been filed against the husband of the petitioner, so that appropriate remedial action can be taken by the petitioner stroke her husband. Full stop. Mr. Chaudhary, Lawrence Senior Counsel for the petitioner, has submitted that a similar situation had arisen in another writ petition, comma, WBC number 219/2024. Full stop. And he has sought for a similar direction as had been passed in the said writ petition. Full stop. In view of the above projected case, comma, this court this court likes to direct the respondent authorities, and more particularly, comma, the Director General of Police, comma, Assam, to furnish the details of the cases which have been filed against the husband of the petitioner, comma, Sri Lakshajyoti Das, and stroke or suspect or wherein. Okay, list the case on
After 7 days, my lord.
7 days. Today is 21. 7. First of March, 9 days. Photo March. Mr. Deori. Self. Counsel for the petitioner shall furnish an extra copy of the writ petition to Mr. Goswami by tomorrow. As requested by Mr. Goswami. A copy of
Just now, my lord.
Okay, Mr. Deori, counsel for the petitioner has supplied a copy of the writ petition along with an extra to Mr. Goswami. Extra copy. For the purpose of taking necessary steps from his end, as requested by Mr. Goswami, a copy of this order be also furnished to him.
Granting item number 56.
Yes, Mr.
Lordship. In this case, your lordship, eviction notice are issued. Your lordship will set aside the eviction notices, instance certain matters are. And it was properly intimated to the, but without considering this, your lordship's order, kindly page 128 onwards, your lordship.
So what happened thereafter?
They have demolished the houses of the petitioners, your lordship.
without proper, not taking steps.
At this stage, we can only issue notice. I don't know how we are going to calculate compensation, Mr. Islam.
I have annex photograph also, I have annex.
By that, we cannot do anyway. Heard Mr. S. Islam Learned Council for the petitioners. You are patta holders.
No, Your Lordship, it's a government land. We are possessing that land for plus 50, 60 years, Your Lordship. That is.
Maybe.
That. Your Lordship, we have paid revenue and neither it is a forest land, neither is a any project.
But
It's simple.
it is a fact that you are on government land.
Yes. It illegal demolition, we have lost.
This may require leading of evidence, Mr. Islam.
Everything I have annexed, my revenue receipt, everything I have
No,
annexed.
is it a read proceeding whether how much damage had occurred? How can I decide on it, Mr. Islam?
I have annexed the photograph also, Your Lordship.
By looking at the photograph, whether I'll see it as 10 lakh, 5 lakh, 50,000. It will be difficult, Mr. Islam.
Your Lordship.
Heard Mr. S. Islam, Learned Counsel for the petitioner. D. Hazarika, Standing Counsel Revenue. Forest. I voted for Learned Counsel representing Mr. P. N. Goswami. Standing Counsel. Environment and Forest Department for respond number 2, 3. Mr. N. Goswami, Learned Junior Government for Assam for responder 4, 5,
And 6.
6. 8 also?
District Commissioner, Your Lordship.
8. Who is PWD? Mr. B. Chud. Learned Standing Counsel PWD for the respond number 7. Who's the petitioners have a list that their properties were demolished by an illegal demolition exercise, illegal demolition stroke through an illegal demolition stroke eviction exercise by the respondent authorities at the instance and the said illegal exercise was undertaken by the respondent number 9 and the respondent number 10. Under the supervision of the respondent number 9 and the
Now they are blaming, Your Lordship. Circle officer said that they are demolished and they said that no, circle officer demolished. That is the case.
9 and 10.
The notice issued by assistant circle officer.
No, you are alleging 9 and 10.
Lordship.
Is it not?
Lordship.
Issue notice returnable in 4 weeks. As so and so appeared, accepted, no formal notice, extra copies. Steps on 9 and 10 by registered post date within 2 or 4 days.
Dosti service may be allowed, permitted to 9 and 10.
Not interested.
Obliged.
Order stay repeating item number 19.
May I please, Lordship? My lord, the writ petitioners has filed this writ petition 6069 by
Before
using
my
some
learned friend
facts.
started, today we have filed affidavit in opposition in the stay vacating IA lordship.
There is no document, only a statement, which are available in writ petition.
Whatever,
Only we could not file it before 10:15, so I have not made a mention. And moreover, Lordship, while issuing notice, BTC council was asked to bring instruction.
what is the subject? Eviction or what?
No, my lord, thing is this, my lord.
The subject, only tell the subject.
Yes.
first.
We have some plot of land.
No, what is the petitioner's case?
Petitioner's case is nothing, my lord. He
May I
has,
submit?
What is your
he
case?
has no locus,
We
even he
are-
has no locus.
Lordship,
We are not entering into it. We are asking what is the subject, eviction, patta,
No,
what
Lordship, we are the legal heirs of one Abdur Rahman, Lordship. Private respondents are also legal
regarding
heirs.
plot of land.
Yes, Lordship,
Dispute.
our names were there, Lordship, they filed miscase, so during pendency, we have filed
What
one
kind
case.
of miscase?
Lordship, for deletion of name of the petitioners.
Okay, revenue record.
Lordship. So
Okay.
revenue records accordingly, Lordship, one settlement officer directed that as we.
You have
all-
filed a objection
Yes, Lordship.
today.
Yes, Lordship.
Okay, Mr. Mahmood, Monday then.
Lordship, may I pray to bring the instruction, Lordship, your Lordship can entirely dispose of the entire petition, Lordship. Status quo, Lordship, the status quo in regard to the land, Lordship, that possession may not be.
Okay,
land
let us first consider the IA, since IA has been filed. If I think that yes, IA
Lord.
cannot be disposed of
Lordship.
without the help of state, then we'll ask for them.
Lord.
Heard Mr. M.U. Mahmood, Learned Counsel for the applicant, and M.S.R. Chaudhary, Learned Counsel for the opposite party, that's petitioner. Post of M.S. Chaudhary has submitted that an objection to the interlocutory application has been filed during the course of the day, and the said objection is not tagged with a case record. Post of list the case, list the IA on Monday, along with the
Affidavit in opposition.
objection filed in the interlocutory application by the opposite party writ petitioner, or the tagged with the case record. Please, Monday.
Outlet.
Number 20.
May it please your lordship, in this case, in IA, we want to file our objection, lordship. By, we'll file
IA
our
is for vacating.
vacating, lordship.
Mr. Soma, you have filed IA.
Yes, your lordship, for vacating.
How much time?
By Monday, we will file our
Monday.
lordship. And lordship may fix the matter after
Next Friday.
Lord.
MS
our data.
R.
Deka.
Deka. Okay, heard Mr. M. Sharma, Learned Counsel for the applicant.
1 and 2.
Applicant. I am passing the order in IA.
Oh, yes, sorry, your lordship.
And MS R. Deka, Learned Counsel for the opposite party writ petitioner. MS Deka has prayed for fixing of the case on next Friday, huh? In order to file an objection to the interlocutory application by 26 to 2024. The interim order passed shall continue till the published.
Repeat the party item number 21.
May it please your lordship. My lord, page number 3, my lord, opposite party number 4, my lord. Matter pertains to, my lord, ex gratia.
Arch Mr. M.K. Das, Learned Counsel for the applicant, writ petitioner, and Mr. S. Borua, Learned Junior government advocate Assam for the opposite party number 1 and 3.
4, my lord, as party respondent number.
One and
No, he has not been also heard. MS and Bordeaux. Learned Standing Council, Revenue Department, Revenue and Disaster Management Department for the proposed party respondent number 4.
My lordship.
First off, the applicant as the repetitioner has preferred the connected repetition seeking the relief of ex gratia in terms of a notification dated 15/11/2014 of the Revenue and Disaster Management Department on the premise that the applicant, thus writ petitioner's mother was killed in a road traffic accident occurred at a public place. So stop. The instant interlocutory application has been preferred seeking implement of the following authority. Quote unquote liki. The Principal Secretary to the Government of Assam, Revenue and Disaster Management Department, Dispur Assam, as a party respondent in the connected writ petition on the ground that the said authority was not implemented as a party respondent in the connected writ petition inadvertently. Full stop. It is averred that the presence of the proposed party respondent is necessary for adjudication of the issues involved in the connected writ petition. Full stop. The learned counsel for the opposite parties proposed party respondent has submitted that they have no objection if the prayer made in the instant interlocutory application is allowed to stop. Having regard to the grievance sought in the connected writ petition in the form of ex gratia relief on the basis of a notification issued by the proposed party respondent number 4, party respondent, the instant interlocutory application seeking implement of the aforementioned authority is allowed, as party respondent number 4 is allowed. Post of the counsel for the petitioner shall submit an amended cause title before the registry in terms of the notification dated so and so within 3 working days from today, and on submission of such amended cause title from the registry to carry out the necessary correction in the cause title as well as in the CIA. So the connected writ petition be listed there.
Deeply obliged.
Is to be listed there. Count.
Please, your lordships.
What is the case about, Mr.
See, here I am challenging the lordship LPG distributorships lordship.
Huh?
LPG distributorship.
LPG
Lordship,
distributorship. Okay.
lordship. The basic ground is that lordship, the persons who were selected is not from the concerned panchayat lordship, as per the priority list lordship.
Priority list.
Lordship.
So in priority list number 1, who should be in the
Priority list number 1, the persons whose names are figure. Petitioners is there, priority list number 1.
You are there.
I am there, lordship. Even
It is within the Gram Panchayat or revenue village. What is
the Gram Panchayat lordship.
priority list number 1 is from the
Gram Panchayat lordship.
Gram
It is
Panchayat.
there, lordship. It is so lordship.
Now, who is the respondent, private respondent?
Private respondent, my brother is appeared, lordship. Yeah.
I am that respondent number 3, Nokibul Islam.
Lordship.
And why 2 petitioners?
2 petitioners, both are also in the priority list number 1, lordship.
Oh, they did a joint venture.
Lordship.
Okay.
Regarding lordship, internship priority lordship is page 41, page 41 lordship. Page 41 is the provision lordship. C lordship.
Okay, Durgam Kshatriya Vitrak.
Lordship.
One is 15C, right?
Lordship 15C.
Clause 1 is Gram Panchayat.
Lordship, eligible applicants reside
Then
in
revenue subdivision.
lordship. Then lordship, eligible applicant not residing in the concerned Gram Panchayat or in the concerned revenue subdivision of the advertised lordship.
Outside 1 and 2.
Lordship.
Now, what is the main document?
Lordship, here the priority list is page 71, lordship. Priority lordship, number one is
Number?
I am lordship, number 3 and 6 lordship.
Okay.
Petitioner number 1 is 6 and petitioner number
Mofidul
lordship.
and Safiruddin.
Safiruddin and lordship, Mofidul lordship.
Hmm.
Mofidul. And the
Okay.
respondent is lordship 4 lordship, Naqibul Islam lordship.
Naqibul Islam.
Naqibul Islam lordship. Here lordship, the
Why you are not making the other as
others
part-
lordship, others persons lordship, priority list whose names are included immediately file a complaint lordship.
whether from this stage
Lordship.
it has reached the other stage? Next
Lordship,
stage.
lordship.
Okay.
Lordship.
Let us see.
It was selected to the lordship to respond number 4 lordship.
Okay, he was the selected person in the drop lots.
Lordship. And from the lordship, when priority list was prepared lordship. At the
What is the main document against him?
lordship, he is from another list lordship.
Gram Panchayat.
Another Gram Panchayat lordship. It is in lordship page 78 lordship.
78.
Lordship.
Particular Dolgaon.
Vernacular is lordship, it is in page 79 lordship.
This is voters list.
Voters list lordship. It is in normative lordship list. And his name is reflected lordship in the vernacular lordship, next page 80 lordship.
And on what basis he has been shown as a
he has been-
resident of the Gram Panchayat
As per his
by the IOC?
as per his affidavit lordship, he has filed affidavit lordship.
IOC has filed or not?
IOC has filed affidavit lordship. File করছে না IOC? And his affidavit, my lord, may kindly take lordship. The
Okay.
respondent-
Otherwise, pleading is complete.
pleading is completed.
Lordship. There is nothing more to add.
Lordship.
Mr. You have anything to add by
No,
pleading
no.
or you?
Complete, my lord.
No, complete.
Lordship.
খালি জায়গাটা ভিডিও মঙ্গলবার মানে কি আছে?
Lordship.
হ্যাঁ? 5-3.
5-3 lordship.
Okay.
Lordship.
5-3.
Lordship.
Tuesday.
Lordship.
Okay. Heard Mr. K. Gogoi, learned counsel for the petitioner. Petitioners, Mr.
Hey Zahid, my lord.
A. Jahid, learned counsel for the respondent number 1 and 2, and Mr. S. Islam, learned counsel for the respondent number 3. Most of learned counsel for the parties have submitted that exchange of pleading is complete. Most of release the case on as sought for by the learned counsel for the parties.
That was 23 and 24.
May I please your lordship? Lordship, Mr. Bigogo is in Lexington Court 1, your lordship.
What is
After
the issue,
open
Mr.
My lord, if your lordship remembers on,
I remember, that is why I am asking.
I'm making the instruction, I'm just placing the instruction as my senior counsel advised, my lord. On last occasion, all on a sudden, after so many years of, almost 2 years,
I was not noticed. Suddenly I noticed. That is why I indicated to you whether,
Yes. Then
because
now-
it was never pointed out to
Never
me.
pointed out. Actually, we did not point out because I think some inadvertency occurred because the registry allotted the case, my lord, to this honorable bench, this matter.
Right.
So we thought that they scrutinized everything and placed it before the single bench. That was the reason it was not placed. So the learned senior said, my lord, to apprise the court, I think this is the appropriate matter for the division bench. So maybe because the question of rule is there, statutory rule, and we are challenging the schedule.
Where is Mr. Das, H.K. Das?
Lordship, due to some personal difficulty, Lordship, he has left the court, Lordship.
I think if it is in presence of Mr. H.K. Das, it will be better that
Yes.
he can route the repetition through the appropriate channel before the division bench. I think. Why? He has left.
Yes, Lordship. Lordship may fix it another date, Lordship.
So that,
I understand, my lord.
so that, because 2 years, more than 2 years have gone by. Otherwise, yes, all but because of some administrative order,
Yes.
all matters related to High Court and subordinate judiciary is before this court. But virus is
There,
so it will be before division bench.
Not
It
dir-
appears perhaps.
derouted again.
Okay, can it be Mr. Abedin? Say, can it be on Monday? So that we can ensure Mr. Das' presence.
My lord, if your lordship permits.
Are you available?
We are available only Tuesday, then we can, I can involve my senior, my lord. I think his presence also would be better for derouting
No, it is
the.
okay. Because virus is
Monday is fine. Monday is fine. I've got-
virus is apparently chilling.
Yes,
Heard Mr. J. Abedin, Learned Counsel for the petitioners. Mr. HK, Mr.
NK Sharma, Lord.
MJ Sharma,
NK.
MK Sharma, NK Sharma,
Or
MS Borua, Learned Junior Learned Advocate, Assam for respondent number 1. MS RM Borua, Learned Counsel appearing for Mr. B. Gogoi, Learned Standing Counsel Finance. Okay. S. Boru 183. And Mr. NK Sharma, Learned Counsel representing Mr. H.K. Das, Learned Standing Counsel, GHC post. On the prayer of Mr. Sharma, Learned Counsel appearing for Mr. H.K. Sharma Das, Learned Standing Counsel, GHC, list the cases on Monday.
26.
So that will, how it is to be, because there has to be an administrative order also.
Yes.
It will be to the registry to the Honorable Chief Justice, then Honorable Chief Justice to division bench, perhaps.
let's see, my lord.
Let's see.
Item 25.
Deeply obliged, my lord.
Your Lordship. This is my lord regarding my lord acquisition of land, my lord. Acquisition of land. Deputy, we are challenging my lord. Order part by the deputy commissioner, case 44. And what happened, my lord, instead of make reference to the court, my lord, the deputy commissioner has rejected our prayer, my lord. Instead of referring the matter to the court, my lord, as per section 18, my lord, the deputy commissioner has rejected our prayer, my lord. And decided to pay the, my lord, compensation amount to the, my lord, respondents. My lord. Page 44 is the, my lord, order part by the, my lord, deputy commissioner. As per act, my lord, deputy commissioner is required to send the matter to the court, my lord, for its decision.
Which one is the 15-7? You are concerned with which DAG number?
We are, my lord. Dag number 48, my lord.
Patta number?
Dag number 48.
DAG number 48 or Patta number 48?
Patta number 155, my lord.
Huh?
Dag number 155, Patta number.
Yes, my lord. Dag number 155, Patta number 48, my lord.
There were two complaints, right?
My lord.
You were concerned with only one.
One, my lord.
In 2013.
Land was acquired, my lord, under Assam, my lord. Under, my lord.
Assam Requisition and Acquisition Act, but provisions are applicable now.
Of the Land Acquisition Act
1964.
1894, my lord.
1964. Mr. Islam, what kind of document you have?
We purchased the land, my lord, in the year 1980, my lord. And we are
No,
possessing.
Sold it.
Sold it was not registered, my lord. It is admitted, my lord.
Then
We are occupying the land since 1980, my lord. And Deputy Commissioner is not the authority to decide who is entitled, my lord. When there is dispute, my lord, as per section 18, he is required to send the matter to the court, my lord.
but first there has to be dispute.
We are possessing the land. my lord.
Valid dispute.
Yes, my lord.
Bogus dispute will not be termed as dispute.
My lord. That is true, my lord.
Frivolous dispute is not a dispute. If it is detected easily,
We are
what is the
possessing, my lord.
definition of dispute? One has to have a bona fide
Yes.
claim. Unregistered sale deed.
My lord.
I don't think it is a valid in the eye of law.
But we are possessing since 1980, my lord. More than 40 years, my lord.
Then you can prefer against the speaking order. What stopped you? What stopped you against the speaking order?
Yes, my lord.
That you have come rushing to the High Court? Or it is whether only it is a deputy commissioner he can refer? Or you can directly prefer? What is the law?
Section 18, my lord.
It is to be.
Section 18,
So,
the Land Acquisition Act 1894, my lord.
did you make any application?
We made complaint, my lord.
No, after this order, page
After this
48,
order, no, my no.
Mr. Suppose if it is under 1964 Act, suppose
Suppose.
the word that the collector shall in every case, section 12,
My lord, section 12.
where any person aggrieved by an award made under subsection 3 of section 11 makes an application requiring the matter to be referred to the court.
My lord,
There is a condition precedent.
my lord.
Suppose there is dispute about sharing of compensation, then he cannot decide, okay, you go on his own. He can send it on his own.
One, my lord.
So far as condition precedent, under section 12A, that aggrieved person has to make an application before him. Right, in the 1964 Act.
Yes, my lord.
Now, what is the provision here?
64.
1894, 1894, my lord.
That is gone. We are in 2022, mister.
2013 Act will follow now. Section 64.
What is the LA case number? Tell me.
5/21, my lord.
You are in the old days.
My lord. But section 12 refer, my lord, in case of reference.
Let us see its 2013 Act.
My lord.
Section 64, Lord.
Now here consists of four situations perhaps.
Yes. Grounds.
One is who has not accepted the award. He is not that man. Next, by written application to the collector, required that the matter be referred to the collector for the determination of the authority, as the case may be. Whether his objection as to measurement of the land, no, he is not.
The amount
Second, the amount of compensation, I don't think
the person to whom is
payable.
it is, my lord. It will applicable, my lord.
So, if you are a person interested, you are claiming to be a person interested.
My lord.
You have to make an application before that. Deputy Commissioner,
As per section.
that please refer the matter to the from all angle.
My lord.
And it is disputed, Lordship, whether he is person interested,
The
whether
court
he is
will determine
position.
that-
This is a matter of proper adjudication by the civil
That
court.
will, that will be, but first he has, condition precedent is that he has to make an application. He cannot, why he is preferring a writ petition instead of making an application?
The impugn order is not award. It is a order whereby reject my claim, my lord. That is why,
Rejected.
my lord.
Still, if you are a person interested, perhaps
That is why we
your
approach-
remedy
My-
is to make an application since you have passed the order, whatever, refer it to.
My lord, we will do it, my lord.
You are pursuing a remedy. Yes, mister.
Your Lordship, my submission is even he cannot file an application before the authority also. Because it's a dispute.
Now, you cannot stop him.
I cannot stop him. I can. Writ petition is not maintainable. It's the.
A writ petition
is not
appears to be
maintainable.
not made.
maintainable.
Appears to be not made. Had he filed an application and it was not referred by the deputy commissioner, then a writ petition could have been maintainable. The deputy commissioner is not performing his duty. But here it is not a case. He has not prepared any application.
We made a complaint against the award, my lord.
Huh?
We have not filed any application to refer the matter to the court. That is.
Where is the complaint?
Then is not annexed, my lord. Notice is against my, in respect of my complaint, notice was issued, my lord. That is that I have annexed, my lord. Page 42 is the notice in respect of my complaint, my lord. Page 42 is the notice.
SHARD. Whether this is really this section 64,
If within 30 days deputy commissioner fails to refer,
no, that is one, but whether he comes within that.
my humble submission, he is not, Lordship, because he neither in revenue records his name appears.
No, no. Whether he comes within section
64.
64.
to whom which is payable.
Any person in the state who has not accepted the award may, by written application to the collector, require that the matter be referred to the collector and termination of the authority. The case may be whether subjection to measurement of the land.
Award is it passed or not?
First lordship.
Award passed, my.
Where is it?
Award is not available with my.
He
No,
has
what
made
is the
affirmative.
statement in the affidavit?
The writ petition, he has made statement lordship. At page,
Oh, award, that is there. LKS
Allegation number 5, my lord.
5 of 2021.
21.
Hmm. Mr. Purakasto,
lordship.
he has completely declined his request. The LA authority, the deputy commissioner,
Lordship.
declined his prayer
Lordship.
as a person interested. He is not a person
He
interested.
is not
That
a
is his finding.
Finding.
Yes.
Whether he will come under section 64.
Lordship, no.
Because any person interested.
Interested. Person interested.
That deputy commissioner has said you are not a person interested.
Yes.
You go.
That's why reference is also not maintainable.
Now, what is it then?
Then there is civil suit. He has to file a civil suit for proper adjudication. Whether he has got a possessory right or something like
Whatever.
title he does not have.
Possession is admitted, my lord. Para 13 of the affidavit, my lord. Para 13, my lord.
Where is award is passed, Mr. Purakasto or Islam?
The award is, my lord.
Where is the provision for award?
My lord.
I would say.
Going to be final, section 37.
Seven.
Mr. Islam, it might be 74.
74 is there, it is. Orange. Will appeal to High Court. No, he is not, I think.
No, here it is any person, Mr. Purakasto. There, section 64 is any person interested. Now, section 74, what is the requiring body or any person aggrieved by the award? Now come to paragraph 8 of the affidavit in opposition of the state respondent. Yes, madams, please. It is the court.
We have five.
Lordship,
That is not the submission. Submission is to assist the court. Filing of affidavit. Please go through the affidavit. Mr. Puragas, it is LA case number 5 of 2021. And thus it is clearly stated an award of amount rupees 26 lakh 37,440
Yes.
has been passed
Passed.
in the name of Amir Hussain. Amir Hussain is your opponent? Opponent?
Amir Hussain, yes, our father.
Your father. Then perhaps it is 74.
74 appeal, Lordship, my appeal submission would be against the order of reference. Authority, against the order of the authority.
Let us see. Oh, who is authority?
Authority is the session district judge, Lordship.
Reference.
Reference
Okay.
64.
Then is there nothing?
Powers of the authority, they are.
No, is there nothing? No remedy
No
against the award?
He is not in zone.
No.
Against the award, the person interested, if I am agreed, Lordship, with the award, I can first remedy is the reference. Then if I am not satisfied with the reference, then appeal. This Lordship would have been maintainable if his name is there in the revenue record. At least.
See, if his remedy is barred under section 764. And he cannot reach the stage of 74 also. If he is stopped from preparing an application under 64, he is also stopped from seeking the remedy under section 74. That is your submission. Then whether it is the end of the road for him.
The civil court not end, Lordship. The civil court, he has to get a declaration for his possessory right or whatever it is, that he is holding the possession over there. Then some right will accrue to him. It is totally denied that he is in possession. And still they are claiming is the invalid.
Kindly see para 13 of the affidavit, my lord. Para 13 of the affidavit filed by the deputy commissioner, my lord. Para 13, my lord.
What is there in the order, there is the end.
No, order in the.
Whatever subsequently made
It is admitted
affidavit
we
that
are in
will not
possession, my lord.
help your case.
Para 13, my lord.
He says you are not in possession.
Mr. Islam, your right have been denied. Right to receive compensation has been denied by the speaking order. 15/7/2022.
My lord, deputy commissioner has no power to deny, my lord. He, deputy commissioner pass an order, my lord, against the award, my lord. Any
Then
person
you have to
can,
challenge the award. If say that this is non-esteem law,
yes, my lord. Deputy commissioner
this
cannot pass,
15/7/2022
my lord.
is non-esteem law, suppose.
Yes.
If you, suppose we say, we'll find out that, but if it is set aside also,
My lord.
it is not the award.
Yes, no.
It is not the award.
Matter will go to the court, civil court, my lord. Matter will go to the civil court, my lord.
Who? How?
Commissioner will file an application.
Award is award.
Yes,
If you, even it is set aside,
my lord.
award remains,
Yes, award remain.
right?
Against the award.
Award remains.
Yes, my lord.
And
Yes.
award, in the award also,
He is entitled, my lord, as per award, my lord. So we
you are not a person interested.
will file an application to refer the case to the honorable court for deciding.
Whether that will serve or not, I am not very sure. Whether I can observe that. If I find that you are not a person interested, your right
That is
should
not-
lie elsewhere, then it should lie elsewhere. I cannot permit you to prefer an application liberty granted. I will not grant liberty. If you are not allowed, you are not eligible to grant, get that liberty.
But deputy commissioner,
If
under what
your
authority, my lord?
recourse is before the civil court, then it should be civil court.
Yes, that is there, my lord. But after passing the award, my lord, under what authority deputy commissioner again deny, my lord, someone claim, my lord? Under what law, my lord? That is also important, my lord.
That is important. That is also important that award is passed.
Yes, award is
Award is passed in LA case number 5 of 2011,
21.
awarding amount to Abul Amir Hussain,
Yes, my lord.
right?
Yes.
That remains, that is not under challenge. Nowhere. Is it challenged?
Against that, we,
In this repetition.
my lord, kindly see, my lord, we file an application, complaint, my lord, page 39, my lord. Before the deputy commissioner against the, my lord, award.
Let us see your prayer now.
Yes.
You are challenging impugn award. Yes, against the award, no. Appeal is maintainable anywhere.
Reference, Lordship.
Against the award is reference, my lord.
Reference.
Section 64 will follow.
Because I am not very accustomed to this 2000.
He is aggrieved with the award. To be aggrieved with the award, he must be person interested. First, he shall have to substantiate and prove that he is person interested.
So, Mr. Islam, first thing,
Ahmed.
you have approached a wrong forum, resulting into a wrong order. But wrong was committed by you first. Is it not?
Wrong application, my lord. Forum
Wrong
is-
application, wrong forum. Approach a wrong forum with a wrong application. So what he will do? He'll pass a wrong order. Your approach should have been an application before him
To refer the matter to the.
to refer. Then he'll pass appropriate order.
Yes. Is the normal.
I think I'll go through it first. I'll not commit that wrong.
Next week, my lord.
I'll not try to commit that wrong. It is not that I'll not commit the wrong.
Next week, my lord.
This court is not that, but I'll try not to commit the wrong.
Next
Like you and the deputy commissioner.
My lord.
He has assumed a jurisdiction which is not vested in him. And you have approached the wrong forum with a wrong application. Those are established.
Yes, my lord.
Now, question is what remedy lies? Find out what is the situation, because that may be a non-escape. That observation that you are out.
I filed a similar case, Lordship, but my status is there, my name is in the revenue record. There is nothing. I admit in that case, Lordship.
Because did you receive notice
Yes,
Yes.
no.
Did you receive notice in the LA proceedings?
No,
Yes.
we made complaint, my lord. Then notice
Yes,
was issued.
yes, Lordship. Yeah, he is called for hearing, Lordship, and at the time of hearing, he cannot be served the document.
Which paragraph? Which paragraph?
In 8,
Huh?
8. 10, sorry, Lordship.
No, that is speaking order.
That is regarding
Is
my
speaking
complaint, my
order.
lord. That is regarding my complaint, my
No,
lord.
I am asking that
Yes, my lord. I understand.
during the LA proceeding, whether these petitioners were put to notice or not.
Paragraph
If they
8.
were put to notice, then they have some semblance of person interest.
I will take
No,
inspection. in
their
that.
case was page 39.
Paragraph
Page 39, may kindly see his application. He says that no notice was issued in this date.
Because there are two things. If he claims to be in position, and the LA authority who has passed the award, he did not recognize any of his right.
They makes an inquiry.
Yes.
Makes an
Paragraph
inquiry. Whoever in position, his name is entered in the inside.
Right. That is why whether he should be relegated to the civil code or he should be permitted to file an application under 64. That is because I should not try to commit one more wrong. Anybody? Apparently your case is clear.
I will file fresh application before the deputy commissioner, my lord. To refer-
Because this court, if don't
Lord.
find it to be a fit case, does not grant liberty also. You will be free to obtain anything, but I will not observe if you are not fit to.
Next week, my lord.
Have you understood?
My lord. Next.
If your forum is civil court,
My lord.
then you should go to the civil court.
Yes.
Heard Mr. H.R. Amil, learning counsel for the petitioner, Ms. G. Hazarika, learning standing counsel, Revenue Department for the respondent number 1. S. Borua, learning junior government advocate, Assam for the respondent 2, 3, and 4. Mr. Mohanto, who is respondent 5? Okay, nobody is available. Okay. SD Purakasto, 6 and 7, Edeka, 8. Full stop. Vera. Mr. Who has passed the award?
Commissioner Kamrup, paragraph 5 of the report.
Don't think, Mr. Rajiv, Mr. Purakasto. See the contents of this order. What he have found? Whereas after receiving the land acquisition proposal from the circle officer, the said LA proposals were checked by this end and accordingly all procedures were followed as prescribed in so and so. He's examined the records only.
Land acquisition bar.
Kindly see the notice page 43. It is the additional deputy commissioner who is normally is the
Land acquisition branch.
LA land acquisition officer. Normally, in most of the cases, if deputy commissioner becomes the land acquisition officer, he will have no other job to do. Right? These are small things, but it matters. This man might have Miss Borua.
Yes.
Please find out who is the authority who has passed the award. Because this man who is passing the order, who has passed the order, he does not have any jurisdiction. It appears so. Miss Borua learned, from the materials on record, from the materials on record, more particularly, from paragraph 8 of the affidavit in opposition filed by the respondent number 2, that is the additional deputy commissioner, Kamrup, Guwahati, it has emerged that an award for an amount of rupees 26,37,440 was passed in LA case number 5/2021 in favor of the recorded patadars, that is Amir Hussain, after serving notices upon him. Post of the order dated 25
15/7.
15/7/2022. Oh, he has passed. The additional deputy commissioner has passed. Has also passed, has been passed by the additional deputy commissioner Kamrup Amingam. MS Borua shall obtain instruction about the authority who has passed the award and an extract of the award pertaining to the respondent number
6, 7, and 8.
6, 7, and 8. Only extract, not the entire award. Maybe entire award is for all the persons pertaining to respondent 6, 7, and 8. Please the case fine.
May I please? Lordship, here in affidavit has been filed by the National Highways against the affidavit of the Kala, Lordship, not against the writ petition. Now, one interesting thing at page 303, the proposal for publication of 3A notice pertaining to these villages have already been sent by the Kala, that is the competent authority. But the National Highway is not doing it. Out of 4 villages that is sent, that pertains to the petitioner, 2 they have already published in the gazetted notification, but 2 remains. They say that it was in the forest clearance, the other 2, but that is not correct because the forest clearance which they have annexed does not refer to the gazette notification that is annexed to the affidavit in opposition of the Kala, because it was already de-reserved by the.
No, what is the story? I have forgotten.
We were denied the compensation with an observation that our area falls under the forest area. We have challenged that. Now the Kala has filed an affidavit in our favor saying that these portions have already been reserved by in the Gazette notification 1965 and notification of 1970. Therefore, the Kala has already sent a proposal for publication of 3A notices.
No, tell me now, what kind of forest it was?
It was reserve forest initially, Sildampur Reserve Forest. But the residential areas were de-reserved in 1965. That is next to the.
Who has de-reserved?
Is a gazette notification by the central government.
De-reservation of the forest.
Forest.
Let us see.
Is the affidavit in opposition.
The running page.
Yes. Huh? 164. No.
In the case of next
minute, one
27,
thing. Because many factual things are involved.
yes. ইখন affected.
What is the name of the forest?
Sildambur Reserve Forest.
Okay, running page, it appears from page 268. That notification is in the year 1965.
1965.
And whether within that area, your land falls?
Yes, we contend that and it is not.
1 minute, one by one.
Yes.
I'm not that fast as you.
No.
268, this is a 1965 notification.
Notification.
Under Assam Forest Regulation. Yeah, our Assam Forest Regulation. Move out. No, move out. Okay, this page 268, whereby this is a notification under 28.
Yes.
Of the Assam Forest Regulation 1891. Now, the entire land area within the reserve forest was described.
Yes.
Right. Now, whether your plots of land fail within this reserve forest.
Initially in 1965, after 1965, it was the reserve as per the affidavit.
No. Can you come to kindly page 268?
Yes, Lord. Yes, Lord.
This is a government notification.
Yes, 1965.
Of the year 1965.
October 27.
Right. Now here please see. Declared that the area specified below was declared to be reserve forest. Right?
Yes.
So Assam government had declared reserve forest and all these coordinates were mentioned.
Yes.
North, east, south, west.
Yes, that's
right.
Yes.
I am asking a simple query.
Yes.
That whether your land fell within these boundaries.
Lordship may come to 270 then. Initially,
I am simply asking.
Yes.
Fail. I asked.
Yes.
In the past tense.
Yes, Lordship.
Not in the present tense.
Yes, Lordship, it fell.
Fell. Then what is your story thereafter?
Thereafter, 270, Lordship would see. May I read?
Yes.
With reference to your letter cited above, I am directed to say that the Governor of Assam is pleased to de-reserve the vacant plot adjacent to the previously de-reserved area of 299 acres in Sildampur RF for settlement of some eligible landless agriculturist. DFO Nagaon division may be asked to work out the actual area of de-reservation.
1 minute. Adjacent to the
From this letter, Lordship, Lordship, to my limited knowledge, Lordship, 299 acres must have been de-reserved, Lordship, out of the reserve forest.
also with my limited knowledge, in the context of section 28 of the Assam Forest Regulation, there has to be gazette notification.
Yes.
By writing this kind of letter, will not make a forest de-reserved. See, these are serious questions. So whether any gazette notification they have brought, this Karbi Anglong authority or whatever forest department, that yes, because making such a communicating such a letter will not do. This
in
will be
page-
completely illegal.
Yes, Lordship, at page 275, Lordship. Lordship, kindly.
I'm hearing, Mr. Vora, it is not that.
They refer, I don't know, but they refer to a notification of 1970.
Where is that?
275, page number 275 of the same.
And the government is pleased to
In-
reserve a portion of measuring so and so for approximate Sildamo Reserve Forest near the previously reserved area under the government letter number so and so to settle. Government letter number is that previous letter 270.
Hmm.
To
And
settle
according to
from
the
landless so and so now.
275.
Transfer to the requested to work out the actual area for reservation. Now, where it speaks about gazette notification.
275, Lordship is reading
Okay,
275.
I'm reading 273.
275, Lordship. In inviting a reference to your letter quoted above, I am directed to say that the government allowed the reservation of another 299 acres of land in Sildampur Reserve Forest for the purpose of settlement of landless cultivators and
Yes.
the
Now
notification
you have
of
come
the
to the point.
the reserving 299 acres of land was published in Assam Gazette White so and so dated 13/10/1965.
Now, is it a part of this record? This notification is part of this record. See, Mr. Bora, that if the notification is in existence,
yes,
right, and thereby 299 acres were de-reserved,
yes,
and within that 299 acres, your land fall,
and
then you have a very good case.
That is my case, Lordship.
So that is what I am
There-
trying to understand.
Yes. Lordship, Lordship.
Then no, all this forest clearance business should not be undertaken.
Yes, Lordship.
It becomes a either allotted land or settled land. In that case, 213 Act or 1956 Act both may come, or either of this may come.
Yes, Lordship.
Then will be applicable.
And Lordship, the competent authority has already sent the proposal for.
Now, where is the forest, Mr. Forest?
Lordship, in this case, forest department is not met party, my lord.
No. SC Forest is made a party and served with a copy.
Where
That's
is
one and number
forest?
13.
Where is forest then? I think that will change the issue.
Lordship, forest department is required.
If
Lordship, as per
this
my
notification is gazetted,
Yes, my lord.
then this is in accordance with section 28 of the Assam Forest Regulation, 1891.
91.
There is perimeter provision in Indian Forest Act 1927. If it gets de-reserved, then 299 acres, right, in 1965. Thereafter, these petitioners are allotted pattas. Then they have a case.
Yes, my lord.
Then they have
No,
to be.
we have
compliant.
pattadars. We have pattas. And
Forest.
And Lordship may kindly see 303 for
Now
once.
you have gone through this case records many times.
Yes.
Whether this notification is available.
Yes, that Karbi Anglong authorities.
KAAC,
Page 266, annexure 1.
not madam.
Gazette notification of our affidavit, Lordship.
266. That is not madam. That is 65. Huh?
260.
Then this is Mr.
October 27, 1965. Assam Gazette.
Then this page 76, it is either a fabricated document. What he says, see, Assam Gazette, file number. Please compare with page 268. FOR SETT 498,
Is it T6 260 a
same
typography?
document,
Yes,
same document.
yes. Originally is at page 268.
By this document, forest oh. Okay, 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 correct, correct. Correct. Then what did happen? What happened? What happened there?
Lordship may kindly come to page 303 for once, Lordship. It's there, a National Highway affidavit. Three zero
30?
303, Annexure 7. With reference to the subject cited above, I here duly signed 3A documents of 4 villages for alignment of Karbi Anglong district NH 56 duly verified. ARO and concerned village survey Mandal under Fulani Revenue Circle. In connection, I am enclosing here with duly signed documents as per NH Act 1956 for publication of Gazette notification for Government of India.
Whether any gazette notification
Yes,
has
yes, Lordship. Then 305. Out 305, this is the Gazette notification. And in 306, Lordship would see out of the 4 villages, they have only published for 2, Horitaru and 3 Sildampur.
page 306.
306, Lordship.
Which
Notification.
table?
And down below.
Is there Bora? This is a notification under section 3 within bracket small a.
Yeah.
Appointing the competent authority for the stretch of land from 49 to 155 kilometer.
Yes, that is
In
the,
respect of 2 villages, Horitaru and Sildhampur, under Fuloni Taluk or Mandal. Right?
yes, our.
It is not that.
Yes,
What is your case?
It is not a 3A notification. It is
Only 3A. First, competent authority is appointed.
appointed. Yes,
Thereafter, 3A notification will come. It is in the process. Now, what is your case?
Out of these 4 villages, we fall under these 4 villages. For 2 villages now they have appointed the authority. For other 2 villages they have not appointed.
No, what is your grievance now?
Grievance is that we have been deprived of the compensation, and the 3A notices regarding our villages has not been published, though our lands have been taken possession of and work is going on.
Possession has been taken.
Work is 80% complete as per my instruction.
Then what are these notifications then? This page you have annexed so many pages here in the affidavit.
In the read petition, Lordship.
In the read petition?
Yes, Lordship.
Running from this page 137?
Yes. Yes, Lordship, that is my case, that our area was initially shown as forest area. Lordship would see at page 135. 135. Is it?
Okay, 135.
Lordship would see serial number 39. 39 Forest Village. So we are resident, you are initially, in the initial 3A notification, our part was excluded and shown as Forest Village. Therefore, we were not granted the compensation. Now, as per the affidavit,
is there any admission from the respondents that the lands occupied by you? you have not been recognized as patta holders. Let us assume for a moment.
Yes.
Whether there is any admission from any of the respondents that yes, this person were in occupation of forest land and their lands have been cleared for national highway. Is there any direct admission from their side?
The competent authority, respondent number 9 has filed the affidavit where it says that though initially our lands fall in the reserve forest, but it is de-reserved by gazette notification.
Well, you are not answering my question.
Sorry, Lordship.
Whether any of these respondents.
Yes, Lordship.
Huh?
I have,
Where is that?
Lordship, page 10, Lordship. Just now he have quoted that 3 notification. In reply to that paragraph, page 10, 287 page, my lord.
287. Okay.
Initially, there were 4 villages, my lord. 2 were included in the 3 notification, but 2 were not included as their forest. And in respect of 2 villages, Lordship, Ministry of Forest also given the forest clearance, my lord. But the petitioners are resisting the construction work. That is why, Lordship, that project also has been stopped, my lord.
You want to say who is responsible number 9?
9 is competent authority, my lord.
Competent authority.
Where is Mr. Chutia? You represent or he also represent? If the area is de-reserved, as far back as in the year 1965, 299 acres.
Yes, my lord.
That is also Sildhampur or what?
Sildhampur.
Sildhampur Reserve Forest. And it was no longer a reserve forest since 1965.
Lordship,
If that is so, because here Indian Forest Act is not applicable.
Lordship.
Here it is Indian Assam Forest Regulation. Though the provisions are very material. Now, this is an exercise under Section 28 of the Forest Regulation. De-reserved. State government has the power. If it is de-reserved already, pattas were issued because Karbi Anglong authority is not competent to de-reserve. It is only the state government.
Lordship.
They have de-reserved.
Lordship, kindly page 297, my lord, of that affidavit. It's stated additional forest land.
Now, anybody has said whether because
Just I want to.
Mr. Bora, don't confuse people. Hard, Mr. D. Bora. Learn it. BP Bora. S. Kemprai, standing counsel KAC. S. Borua. Okay, Mr. S. Boru, MS S. Boru, Junior Government Advocate Assam for the State Respondents. Mr. C. Borua, Standing Counsel, and Mr. NHAI, and Mr. R.K. Talgar, Standing Counsel. You are for
NHIDCL, my lord.
NHIDC. Good. From the submissions of the learned counsel for the parties, and also from page number 268 of the case papers, comma, it is noticed that a reserve forest, by the name of Sil Thorampur Reserve Forest was declared by a notification dated 27/9/1889. Under the Assam Forest Regulation 1891. Full stop. By a notification dated by a gazette notification dated number FOR stroke SETT stroke 498 stroke 63 stroke 26. Dated 13/10/1965, issued in exercise of powers conferred under Section 28 of the Assam Forest Regulation, 1891, and published in the Assam Gazette in its issue dated 27/10/1965, an area of land measuring 299 acres with a specific boundaries described therein, had been de-reserved and declared that the said 299 acres shall cease, CEASE, shall cease to be reserve forest with effect from 27/10/1965. Full stop. The petitioners claim that they are periodic patta holders in areas, other than forest areas. Other than forest areas. Full stop. Learned Standing Counsel, KAAC, shall obtain specific instructions as to whether the periodic pattas issued to the petitioners are within the areas of 299 acres within the definite boundaries notified by the notification dated 27/10/1965 or beyond or outside those 299 acres of land. That's all. If you are within 299, you are entitled. If you are not within 299, you are out. MS Kemprai, Learned Council for Learned Council, appearing for Standing Council, I have already mentioned.
Can it be on Monday or Tuesday next?
Okay, very good. If you are so fast. You 20, 4th of March.
4th of March.
Release the cases on 4th of March.
Okay.
Yes, all of meeting is okay. Please continue.
May I please your lordship? Lordship, I have a small prayer in item number 46, lordship. Lordship may fix it for admission. In fact, I have mentioned on the Friday also, lordship. Service has been complete, lordship. There is some urgency, lordship.
Slide 46 to DD Bhattacharya. On the prayer, Mr. N.K. Sharma, Learned Council for the petitioner, release the case on Friday.
For admission, lordship.
This is an admission or what?
Orders, lordship. Item number 46, lordship.
Okay, in the admission column.
Lordship. Deeply
On
obliged.
next Friday. It's Friday, no, next Friday.
Item number 47, Lordship, that the interim may be continued.
47.
Lodge,
Okay.
interim.
On the prayer, Mrs. J. Quilter, Learned Council for the petitioner, release the case after a week. The interim order passed Friday shall continue till the next date.
Well, it's item number 28, my lord.
Date 47.
Wait, please, your lordship. Your lordships, I have a prayer with regard to item number 36. Your lordships have heard this matter regarding the service tax matter. Lordships, there's an interim in this matter, your lordship, that we can kindly continue.
Mr. Kyle was supposed to bring some notification only. That's all. Okay. MS Sharma. S. Sharma.
Yes, your lordship.
Learned Council for the petitioner is present. And Mr. Kyle is available. Order some. Give a notification. Otherwise, to Puna Hushil, no? Kali give a notification. Keep it. It will like, no? Release the case for submission of synopsis of written argument by the Learned Standing Council GST. The interim order passed.
Perhaps they have submitted, your lordship, because before it was listed before Justice Jyotan Kumar. Perhaps they have submitted.
Now it is no time to examine all those. Beyond
Only prayer, well, item
interim order is extended.
Well, item
12.
Item 28, my lord.
7-3. Yes, MS Sharma, 7-3.
Item number 46. Item number 49. Internet.
Aseni ki main. Now,
Item number 49.
One item.
Any instruction, State Council? Okay. Mr.
Well, item 28, my lord.
1 minute, I'm recording. Okay, Learned Council for the petition is present to stop. The state respondents have not filed any affidavit, any response, counter affidavit till date. To stop, please the case dated at 3 weeks. The interim order passed earlier shall continue till the next date of listing.
Item 28, first week of March, my lord, at any date, my lord. 28. 28.
What is
my lord, there is
subject matter?
My lord, the renewal of license of pharmacist, my lord, that is pending.
Pharmacists.
Yes, my lord.
All those pharmacists whose license have been cancelled and must say.
Yes, my lord, that after
Then-
after there of inquiry was come, my lord, in favor of him, my lord. But even then, after made an inquiry, my lord, that is in favor of him.
By the judgment or
Yes,
what?
my lord, after judgment.
Judgment,
After judgment, he made an inquiry, my lord.
made an inquiry.
Yes, my lord, that is, his
Your
license was
license
found
is
as
found
genuine.
valid.
Found as genuine, my lord, that's
Found
why.
genuine.
Genuine, this word is,
Okay.
exact word was there.
C. Goswami, learned counsel for the petitioner, has sought for listing of the case after a week. Did you get it? Release the case.
33.
My lord,
My
item
lord.
number 48, my lord.
Yes, Mr. Chaudhary.
My lord, item number 31, there is an interim stay. It may be allowed to continue and there are some developments, it can be fixed. on
Okay,
the
Mr.
6th of March.
You are for petitioner?
Petitioner.
Okay, Mr. B. Chaudhary. Jyotsna Dev.
Yes.
Counsel for the petitioner has submitted that there are some certain subsequent developments. He has sought for listing of the case on another date. On the learned, sorry, there is no counter affidavit filed by the Secondary Education Department till date. In deference to the order dated 17/11/2023. Full stop. Release the case after on date of the DDO.
6th of March.
It will be too early. They have not filed any affidavit.
Yes, madam.
15-3, the interim order passed earlier. Shall
Much
continue
obliged.
till the next.
Item number 48, my lord. And, perhaps this is a bench 3 matter getting listed before your lordship. I don't know. It's a matter.
Mr. D. Chakraborty, learned counsel for the petitioner, and Mr. Who is state counsel?
My lord,
Anybody available?
Mr. Siddharth Barua was in this.
As Burwal and Junior Government Assam have submitted that. Okay. The subject matter of the petition pertains to bench 3. The office to verify the same and thereafter release the case before the appropriate bench.
Obliged.
Lordship. Item number 35. That may be fixed for admission.
Any interim order?
No.
No interim order. Yes, no. The request of Mr. So-and-so, your name?
Rishi Bora.
Release the case after a week. Will not fix in late. There is no response. Yes.
May I please, Your Lord? Lordship, back to mention item 45, Your Lordship. Lordship, the matter was earlier coming on admission column, but today is what listed on order column as I have filed an amendment petition and impleadment petition, Your Lordship.
Impleadment petition?
Yes, Your Lordship. There are 3 parties are impleaded and notice may go up on that.
No, impleadment petition has to come
It-
on
it was-
record, Mr. Counsel.
Yes, it was allowed, Your Lordship. On 5th of January, it was allowed, Your Lordship. And I have also filed the amended cost title, Your Lordship. 7, 8, 9, they are impleaded, Your Lordship. Notice may go up on this.
On the request of Mr. S. Islam.
R.M. Mazumdar, Your Lordship.
R.M. Mazumdar, learned counsel for the petitioner has submitted that the writ petition has been wrongly listed in the orders column instead of admission column. Release the office to verify the same and thereafter release the writ petition in the admission column after a week.
Lordship, notice may go up on 7, 8, and 9.
Mister, we are at 440, Mr.
Otherwise, the purpose is frustrated, Your Lordship. That's why it was listed, Your Lordship, order column, maybe, Your Lordship.
Mr. Counsel, if I been able to do all the cases, I would have done it.
Oblige, Your Lordship.
Right.
As any date may be fixed, Your Lordship.
I have seen after 1 week. Within next week, next week.
May it please, Your Lord. Lordship, item number 32, it was a RTI related matter. Today, they were supposed to appraise the court with regards to the status of the documents that they were supposed to provide us. Date may be fixed, Your Lord.
Date,
Obliged, Your Lord.
32.